May I please, Your Lordship?
Yes.
With the consent of the other side, I beg to mention item number 10 of today's daily list, my lord. But in this case, my lord, engaged counsel is from Bombay, my lord. He is presently out of India, my lord. Can we accommodate, my lord, some other date, my lord? If convenient, my lord, 9th or 16th day, my lord. I mean, other side is
I'm
also
not fixing a date. I'll release after 2 weeks.
my lord.
Item?
10, my lord.
Okay.
9 is also take.
9 and 10 are tag metal also.
Okay. You've taken consent for 9 also?
Yes,
Yes, my
Lordship.
lord, the other side
Oh,
is
sure.
present.
Okay. On the ground that the council holding a brief is out of station. Matter stands adjourned today. List after 2 weeks.
There is an interim order, my lord.
Oh, that is the whole difficulty. After interim order, there is always an extension of time.
Therefore, I am asking for praying for fixed date, my lord. It can be disposed of only next day, my lord. Is there already, my lord?
Interim order stands extended. First of all, as the petitioner is enjoying interim order, on the next date, it is expected that the petitioner will not take an adjournment.
My lord. Obliged.
Just like both sides are present. Yes,
That is, my lord. I beg to mention for listing of an item.
listing, give it to the court master. I'm not entertaining. Give it to the court master.
Your Lordship allowed for on last Friday, but due to paucity of time, matter could not reach Lordship. Can it
Give it to the court master. You see, it can't be helped.
Like-
It can't be helped.
of that?
Supplementary cause list item number 11.
Have you noticed something today? When we list matters, there are prayers for adjournments. And when I list it, then you take an adjournment. You don't allow others to do the case. And the lawyers who are waiting for doing the case, the matters can't be taken up. And the request for a listing still comes in. Yes, item.
Item number 11, delivery of orders.
The court has held that it's a highly disputed question of fact, which cannot be effectively determined in writ petition, and therefore writ petition is dismissed by providing that this order shall not be a bar for the petitioner to approach the jurisdictional civil court for adjudication of his grievance.
Obliged.
For motion item number 1.
Your Lordship, for time being, time pass over the matter for a while. The main counsel, outstation counsel. So he's coming.
It may be taken 2 lots.
At 2, okay.
Much obliged.
Well,
Your Lordship.
Yes.
One of the subject matter of the writ petition is the election of the president of the board of directors of the cooperative society. Now, what happened, my lord?
Yes, Mr.
the-
Talukdar, you have to state. You have to state, according to what is being presented, that the notice was not served. These annexures show that all are complaining that notices were not issued. Page 43 onwards.
In fact, my lord, after this is this resolution, the approval has to be given by the RCS, that is yet to be given. Therefore, there is no difficulty in staying also.
Till next week, you don't give that. The page 41 onwards.
Yeah.
Everybody says that notice is not given.
My lord, that is a matter of record, but since, my lord, they want a meeting, in that meeting, everybody wants to be participating. So now your lordship may fix a date, meeting may be held. I think well, it's subject to what my learned senior says, well. That may be done. Lordship may dispose it of.
No, you see, the difficulty is this,
Because as on date, my lord, the records is
no,
not
no, the
with me.
difficulty is respondent 6 and 7.
My lord.
I can't dispose it of without giving a notice, but I can make a observation that this will not be a bar for the ARCS to do it.
No, no, in fact, your lordship will see, my lord, eventually after adjudication, the prima facie, my lord, if the notice is not served, then my lord, the meeting is to be held, my lord.
No, that's what I'm saying.
Yes.
But you see, if I am disposing of a writ petition
Right.
without issuance of notice, somebody may come up and say that this is a false case made out. So I'm issuing a notice because I have to.
Yes.
But I'm saying that the ARCS
Right.
will it will not a bar for him to permit a fresh meeting to be held.
Right.
So he can take a decision. We are permitting that.
Right.
The difficulty is that 6 and 7 may come and say that the petitioner is false.
Correct.
Mr. N.K. Chaudhary, senior counsel, assisted by Mr. T.N. Srinivasan, I'm the counsel for the petitioner. Petitioners. And Mr. S.K. Talukdar and Mr. Srinivasan for the Corporation Department, appearing for respondent numbers 1 to 5. Next paragraph. If you notice a motion, return over on so and so.
2 weeks.
My lord,
Is
I
it-
think there is a caveat, my caveat is appearing. Shows, my lord, there is a caveat,
Ah, yes, caveat is there.
my lord. And Mr. I think my lord, Mondol is appearing. I don't know, but his
Mhm.
name is shown, my lord.
Oh, then you can dispose it of if it's not there.
Correct.
Okay, I did not see that.
We have served the caveat.
None of you can call for the yes, you have come.
এইটো মাতিছে এইটো মানে
Yes.
মিটিং কাটিব পাৰে নহয় এতিয়া বিদ্যালয় কৰিব বাট caveator. Malad, we are appearing for Malad the caveator
Yes,
of respondent number Malad 6 and 7.
yes. You have to state, or if you want, we can fix a date. You can go and have a fresh meeting.
Fresh meeting Malad. Yes, that will be better Malad.
Okay.
Malad. Date may be fixed
Next-
Malad, so that
next thing-
Malad.
Makes the work easier. 15 days. You choose a date, both of you, Mr. Come decide.
Let there be notice, my lord, the period is there only under the.
No, now we'll fix it. All the
Since we
parties are there.
reporting to honorable court.
He'll give a normal, formal notice, but this notice,
that is
now the
enough,
court
Mandal.
is fixing it.
Yes.
Mr. Mandal,
My lord.
go to that side and speak to Mr. Chaudhary and fix a date.
Fifteenth of June,
15th of June.
that will cover the, my lord, that period required by the
Okay.
bylaws also.
No. Dispose. Okay. Also had Mr. M. U. Mandal and the council appearing for respondent numbers 6 and 7 caveators.
1, 2, 3, 4 Malad.
Which one?
Okay.
Yes, I have recorded. Only Mr. Mandal's.
Mandal,
I'm adding.
6 and 7.
In view of the nature of order proposed to be passed, comma. The court finds there is no point issuing a notice of motion in the matter. Next paragraph. The petitioners are all elected members of the board of directors of Paschim Bedbari Samabay Samiti, Barpeta. The elections were held on 8/5/2023. The elections of the board of directors, right?
Yes, my lord.
For the board of directors were held on 8/5/2023. And results were declared on 10/5/2023. Stop. The secretary of the said Samvaya Samiti, within bracket respondent number 5, called a general meeting on 23/5/2023 for selection of the election of president and vice president of the new board of directors.
My lord, may I correct it? In fact, that cannot be a general meeting. It should be a board meeting. Because in a board meeting, my lord, the election is.
It's not a general meeting,
Yeah.
board meeting. Right, you're right. Board meeting for the selection of the election of president, vice president of the new board of directors for the year 2023-28. Full stop. The petitioners herein submitted a representation before the respondent number 5 to inform that they received the notices in the penultimate hour, and therefore requested for fixing another date for convening a board meeting. Full stop. The petitioners have annexed the said representations at annexure C
D, and E, my lord.
C to E of this writ petition. Full stop. Nonetheless, the elections were held on 23/5/2023 by electing the respondent number
6 as the president, 7 as the vice president.
This is 6 as the president, and 6, namely Ataur Rahman as president, and respondent number 7, Abu Ryan Khan as vice president of the said Samavaya Samiti. According to the agreed petitioners are before this court, by filing this writ petition under Article 226 of the Constitution of India, asserting the resolution taken in the meeting dated board meeting dated 23/5/2023 for election of president and vice president. Next paragraph. Although the learned counsel for the aviator of the respondent number 6 and 7 has opposed this pair, but considering the fact that prior to the holding a board meeting, on the date of holding of the board meeting, i.e. on 23/5/2023, 2 of the petitioners had submitted a resignation for postponing the election process. The court is of the considered opinion that ends of justice will be met to direct the respondent number 5, i.e. the secretary of the Paschim Bedbari Vice Committee, to hold a fresh board of directors meeting for selection of the election of president and vice president of the new board of directors for the year 2023-28. Next, accordingly, it is according to the report, is inclined to interfere with the resolution taken by the Board of Directors on 23/5/2023 for election of the respondent number 6 and 7 as president and vice president respectively of the Paschim Bedbari Samavaya Samiti Limited. At the same time, the respondent number 5 is directed to hold a fresh meeting of the Board of Directors of the said Samiti on 15/6/2022, 23, as agreed to by the Learned Senior Counsel for the petitioners and the respondent number 6 and 7. It is also provided that insofar as the petitioners and the respondent number 6 and 7 are concerned, as the order is being passed in their presence, no fresh personal notice is required to be served on them. So insofar as the other Board of Directors are concerned, the respondent number 5 shall ensure that at least 7 days clear notice is served on them,
Bylaws require my lord 15 days.
which are 15 days. 15 days.
That was the my lord AGM and election. So far the my lord boards meeting is concerned, my lord directors of boards are concerned. 7 days is my lord sufficient.
Sufficient. Okay.
Yes.
We'll add one more day, 8 days. Clear notice be given to the remaining Board of Directors. Serving the notice to them personally or to any adult member of their house by taking an acknowledgement and the identity of the person receiving it. Next, but according to this written instance, allowed to the extent as indicated above, without issuance or notice on the respondents. At the motion stage. Without issuance.
Give God bless.
Give it stand is there. Give it is Mr. Mandal.
Highly obliged.
RT
Yes.
So this is eviction notice, the last phase of the petition. Should they are in occupation of the land. And some of them, the petitioner is educated youth lordship, then they started the business there. It is there at lordship, the lordship can vernacular is at page 40, lordship. It is last page of the petition. And then translation is at page 39. It is under the direction of the district magistrate lordship, not the deputy commissioner lordship. I don't know why. It is the 18(2) is the deputy commissioner lordship, not the district magistrate. Secondly, lordship, the log number is there.
That is used interchangeably. Doesn't, because you see down below there is a copy to the district magistrate. So it's just used interchangeably.
So it is copy was sent to.
It's okay, but it's the same man. Because you see in most of the other parts of the Hindi speaking belt, they don't even notice. But you see, in most parts of the Hindi speaking belt in the northern part of the country, they don't even know to speak deputy commissioner. They all say collector.
There is the collector.
Everybody will say collector.
It is collector, because all of them are accustomed to this acquisition and all that lots of acquisition. But my point here in lordship, in view of the now there is land policy, all that lordship, my only here lordship it page 14, paragraph 19. We have already given a kobula. It is under consideration. It is 8 lesses of land. I am there for 1 katha, 1 lesses of land. The kobula is there. As per the land policy lordship, the last land policy, it is very specific. And there is a division bench judgment lordship that if the kobula is pending, let them consider and then only decide. I am there in possession of 1 katha, 1 lessa of land. And the last this court in a division bench judgment lordship And so motor PIL. The division banks specifically provided that loss, that's why loss. It is a so much of PIL lawsuit and it pays paragraph 20 lawsuit. It may not be, it is a certified copy lawsuit, it may not be para 20, but the para 20, it is para 20 lawsuit. We specifically provide that a process of initiating eviction of illegal encroachment from government land and a claim made by any person, including the encroacher, for being entitled to allotment of land under the land policy of 2019 are two separate and unconnected issues, and both are not interdependent for each other. So now accordingly it is decided the following directions were given at para 23. And the Roman 2 is, if any of the person make any individual application for allotment of land under the land policy 2019, the deputy commissioner shall subject such application for its appropriate consideration under the law and pass a reasoned order, whether in fact and circumstances the individual, the person concerned has any legal right for allotment of any government land, and accordingly, if the deputy commissioner is of the view that the given person is not entitled, a reasoned order be passed, and on the other hand, if the deputy commissioner is of the view that if somebody has any kind of entitlement, again another reasoned order may be passed in respect of the such person. So that much consideration at least lawsuit, because my client has taken the position who is there from 1945 lawsuit. It is not only 2001 lawsuit. There this one kata one dasas of land since 1945. And then educated bachelor, no VA, no service, nothing lawsuit. There is no government job. He started a small business lawsuit running his family. And then it's a small grocery shop lawsuit and so let them not evict them, consider the Kabula. Kabula have annexed, they have received the Kabula, given the number. It is pending before the deputy commissioner.
Yes.
Yes, this is a government land, and land is reserved for market matter, Tolohar market matter. That is why
No, nobody stopped you from rejecting the Kabula.
yes,
You accept it, put it into cold storage and then evict him.
that is true, my lord. But this land is reserved for my lord,
It's okay.
Tolohar market, my lord.
It is.
Yeah,
Nobody figures of land.
No, has the deputy, please ask the deputy commissioner by phone. Somebody has stopped him from passing a final order in this application for land settlement.
Yes.
So take it up at 2 o'clock. So call up the deputy commissioner and tell us whether anybody stopped him from taking a decision. At 2 o'clock.
That is true, my lord, but I can take instruction, my lord.
Page 37 is my Kabula. Annexes 6. It is pending since 30/11/2021 lawsuit. No decision.
At 2 o'clock, what happened to that?
Lawsuit.
Release item number 2 for everyone.
So in this case, I'm paying for the respondent, National Highway Development Authority. But the writ petitioner has filed an additional affidavit. So I need to reply, that's my instruction, I need 3 weeks time.
Okay. Both sides are duly represented. Mr. PJ Segar and Senior Counsel appearing for respond number
1 to 4.
1 to 4. have submitted that he has been served with his instructing counsel has been served with an additional affidavit filed by the petitioner on 25/5/2023. And he seeks praise for him granted 3 weeks time to take instructions and to file a reply. So advised. List after 3 weeks.
Pay for a fixed date, my lord, on 27 or 29.
I'm not fixing a date. You make a mention, we get it listed.
Publish.
14 to 17.
I think this was heard by me.
Yeah, initially, we are good before lucky, but unfortunately.
My lord, 14 and 17 are slightly, my lord. The 3 matters were heard by your lord.
Huh? You are lucky to.
No, because my notes are there. If
Yes,
my notes
yes,
are there, I
yes.
can recollect.
Yes, you are
What
lucky,
is
had it
transpired?
on 14/12/22. There is 7138. My lord. Heard it when the local released on 21/2/22. It is a press hearing, no?
Incidentally, for writing these notes, I'll have to express my gratitude to you and to one Mr. S.L. Kapoor from Calcutta, Senior Counsel. So now, once these notes are there, I don't have to open the file.
It is always helpful. Look, the first case is 7138.
He rebuked me in front of the court when I was instructing Mr. Kapoor.
Yeah.
He rebuked me in front of the court, Justice Vaipai, Honorable Justice Vaipai as well then. Because the court asked a question and I was opening the brief and finding out that paragraph. So he rebuked me in front of the court, closed the brief, took an adjournment. Since saying that my instructing counsel is not prepared. But before going, he said that your lordship will open the brief at page number so and so. This is the paragraph. This is what is said. So something which was very fantastic because he could recollect the entire paragraph and tell to the court. So I asked him that if you knew it, why did you take an adjournment? He said, no, I am a senior counsel. You'll have to instruct me. So I'll not say anything which I know. I will be going only by instructions. Then therefore he took an adjournment. So that day, out of shame, I had to perfect this art. So therefore, 2 persons I will always acknowledge.
Look, the
Your case, if I can recapitulate, so that you can
Yeah.
say which is missed
Yeah.
out. Due to COVID, this railways were totally closed from 26/3 to 24/10/21. Then there was a relaxation at page 133
26,
for
3,
deposit of
19,
license
11,
fees,
21.
that is 2/11/2022. Page 133 is the relaxation for deposit of license fees.
Correct.
Then you refer to a notice inviting tender at page 19, where the e-tender was to open on 9/11/2022.
Yeah.
And the payment schedule you referred at page 26.
Yes. That clause, offending clause, which you have.
Yes.
mentioned.
Now, your question was that whether this was a departure from the from the requirement of page 133.
Yes, that's.
And by arbitrarily reducing the period to 6 months, the relief of quarterly payment, you said that quarterly payments were to be made, but it was
In advance.
in advance. Now it was 6 months, so it is affecting you.
Yes, it did. But in spite of the interim order, all these cases, they have paid that 6 months period. So that way, my lord, the interim matter has it has become academic, but the main question remains, my lord.
Okay.
And a very short issue, namely, my lord, the COVID period, my lord, saw.
You said on that day that only two trains remain. For 6 trains, your full payment was made. So what is left is only 2.
For all, no?
Now it is
I have
all.
told me that for all
Oh,
now
okay.
it is paid. That is no dispute on that. That's okay.
Yes. Okay.
So your lordship summed it up very well, Milord. I don't want to trouble your lordship. Because
But this, there's one
Hmm.
point I couldn't, in fact, follow it. This Gitanjali case, you said that the clarifications were assailed in other petitions. Gitanjali,
Yes, yes.
train.
Because second, they issued a notice after the.
This is
interim
something I
order.
could not follow on that day.
After the interim order in the first case, they issued another notice saying that this order is only confined to Gitanjali, that train.
Okay, this is
and-
something I couldn't follow. You can please elaborate.
No,
This point.
yes, Milord, the one of the petitioner, Jayanto Ghosh, had that train.
Okay,
So they were saying that that particular tender covered by this 7138, the first case, only relates to Gitanjali. Therefore, it is not applicable to other trains.
okay.
That's why we have to come before a lordship, and this interim order was repeated. But as I am saying that this has become a little academic now. So your lordship need not bother about whether the interim order should be continued or not. It's not we have paid. So that part is over. For the first 6
So
months.
what is the point which remains now?
The point is simple, Milord. If your lordship I'll just refresh first, Milord, the page 133. Your lordship has already recalled that order. I'll just, for the sake of my argument, I am just pressing this. Page 133. Relaxation in time period.
Just a minute.
I'm sorry. Seven, 1, 3, 8. Yeah, there also this.
Yes, 133.
Yes, Milord, this is the order dated 2/11/22, Milord. It refers to Roman 2, our representation dated 27/9/22. What happened, Milord? During this 20 minutes, when the train service was closed during COVID, they could not fly their trains, obviously, and their business came to a halt. But they were also asked not to terminate any of these employees, so that liability continued. So there was a problem for these operators also. Therefore, they represented before the authority that this is the situation. At least if advance payment is deferred and installment on 6 monthly quarterly installment is granted, it will help us to restore our position to some extent. So that was considered. And on 2/11/22 is the order by which, Milord, this prayer was allowed. Reference above
IRMCA representation, that is the association's name, dated 27/9/22, has requested to allow to deposit the license fee on quarterly basis for a period of 1 year for management of onboard catering service in trains. The matter has been examined and it has been decided by the competent authority that all SBD and long-term tender licensees within bracket RSDZTV. This stands for R stands for Rajdhani, S for Shatabdi, D for Duranto, Z for Gotiman, T for Tejas, and V for Vande Bharat. It is all those trains. ME, that is Mail Express, and TSV, that is the train side center that in the platforms, shall be permitted to deposit the license fee on quarterly basis for a period of 1 year only. So it was a limited period concession, not about the amount, but about the mode of payment. Instead of requiring them to pay in advance for 6 months, it says you pay quarterly. And quarterly and the concerned tender which was floated, which your lordship will find at page 26. Last part, that is the offending clause, which is under killings. License fee payment schedule. The above quoted license fee for 6 months is to be deposited by the successful bidder within 5 working days of issue of LOA, letter of award, or 5 working days before date of commencement of operation, whichever is later. Letter of acceptance is to be submitted within 5 working days of issuance of LOA. License fee for next 6 months extension period, if applicable, is to be deposited 1 month before the completion of the first term of 6 months. So this is a departure from what we have seen, Milord, at page 133, namely the mode of payment quarterly basis. Instead of that, they said that you have to pay the 6 months in advance, and if it is extended, again in advance. So this is the part which is being questioned, and that is, in short, is the only issue. The question is, my lord, having granted that prayer by the order at page 133, is it permissible or is it fair and reasonable to depart from it while issuing the tender and directing that you have to pay in advance? Because the whole purpose of the 211 order was that they need a little help. Therefore, quarterly payment was conceived and insisted. And it is a 6 months period to be extended if necessary by another 6 months. I am told, my lord, that this 6 months plus 6 months is going on for quite a while, even before it started, before the COVID period. And they do that, but they were paying in advance the entire amount. And that was the departure which was sought to be requested after COVID because of those situations, objective situation. And the competent authority also thought that this mode of payment can for a year be changed, and they may pay in quarterly basis. That was the whole idea. So having taken that decision, you are giving by one hand and then taking away the same benefit by another. That is what it comes down to. Whether that is a little arbitrary and fair and reasonable. That's the short issue, but nothing more. Because it is a 1 year period affair, and in fact, for first 6 months, they have realized now, because they issued notice of all kinds of pressure comes, because they also, these are businessmen, they were sitting idle for 20 months, they had to do something, and therefore, they managed to pay for the 6 months. But suppose the normal practice which is on 6 months plus 6 months goes, so it has some relevance because the 1 year period has not yet expired. It is up to November 23. So if 6 months ends within that and the remaining 6 months come, we get that benefit which was conceived, namely quarterly basis. You get your full payment, but it's a matter of just quarterly payment. And the period is also fixed. It's not as if it will be for all time to come. It is only for 1 year. So November 22 to November 23. First 6 months in fact, we have not been able to get the benefit because we were forced virtually to pay it. So in the event, they normally will not extend for next 6 months. That is the practice going on. So that question will be relevant. And only for 1 year affair, nothing beyond that. Therefore, my lord, the issue is only that. Therefore, basically, my lord, I have a twofold submission. First is, my lord, your decision of 211 should apply to all trains. A broad submission, but it is confined to the specific trains that are mentioned in that order. So, humble submission is that if it is an objective situation, therefore, this should apply to all the trains. But if your lordship is not very inclined to accept that, the alternative argument is that in any event, these petitioners have got some of these trains which are mentioned. So at least for those trains, they are entitled, and therefore that should be given. And we prepared a little chart, if it may help your lordship, because they issued the tenders, whatever 84 trains, which is page. We have let's check the dates.
We must have a borderless court. We must have a borderless court.
So we are just giving one petitioner's thing, Lord. So this is for one of the petitioners, Lord. He is getting these trains, and some distance and all that, and this should not be page number 94. Page number 94, serial number 6. We have indicated below the trains which are he got, And these are trains, which come within that, those categories. The first is Gitanjali, then the other is Mail Express, the other is Duronto, Ranjana. So these are covered by 211. So in our respectful submission, they will come within that scope of 211. And we have given the alphabetical full names. Similarly,
This
the other,
page 94 would be from 7597.
yes, yes.
Yes.
Hold on. 7597. I'm sorry, Milord, it will be from 7597.
Yes, yes, I found, I've seen
Yes,
that.
I thought it was.
This is first and second. Yes.
7597.
I've seen that. Prior to these catering days, when I was a small kid, my parents used to know which station the train will stop for how much time, where should I go out, have our food and bring it back because I was a vegetarian. So they knew also those joints that you will get milk there. Go outside, you will get milk there. You will get this there. So those things also was a part of the travel routine.
Yes, yes.
Knowing where to get down, where to have food.
Yes, yes. That is very important. One of my friends also, he was, somehow, he is no more. He retired as a principal of Commerce College. So he used to go with the cricket teams
Okay.
for university, state, everything. So he knows that way.
Okay.
So once we went to Darjeeling with him, so he used to know that this is the stop we'll have to get our meals. And he knew everything. So your lordship also is familiar with that. Nowadays, I think things are much better.
Much easier.
Yes.
Traveling is much easier.
So 94 is the. These are the Mail Express trains below. And that the host is serial 6 and 10. Which are also seen in that chart. No? Page number 94. People have put this. Then the other is at page 179, that is I think in 7597. In this chart of Jayanta Kumar Ghosh below, page 94, 6 and 10, the Lordship has seen. The other trains are at in 7597, which is at page 179. One seven. 179, that page in the WPC 7597. This is Rajdhani, so Shatabdi and Duronto trains. Then here we got it 5, 6, 13, 14, and 15 trains. So this is the chart for the. This 179 is actually the petition is 7597. The earlier one is 71. So this. So these are trains which are contemplated under that 211 circular. Therefore, in that view of the matter, these are permissible. The other two. Classic is no more before your lordships because they have withdrawn from the case and gone. So only Jointo and Krishna. And Krishna's chart is also handed over to your lordship.
Yes.
We got from page.
Jonathan, Krishna, they are still continuing.
They are before your lordship.
And this,
Classic is no more there. So
Kumar 7624,
yes. Krishna.
they are continuing.
They are continuing.
Okay.
Jayanto and Krishna are before your lordship. Classic has gone, withdrawn the case and gone. He is no more before your lordship. And so far Krishna is concerned, and this is also 7 months. On 7 minutes.
Okay, Classic was petitioner number 2 in that case. So he is no more.
He is no.
Okay.
Yes.
But the petitioner number 1, Krishna Enterprise is still continuing.
Still.
Oh, okay, okay.
So two are before your lordship, Jayanto and Krishna.
But I did not find any order for that.
I told me that there is an order, so far as Classic is concerned. He is getting permission to.
Chaudhary, can you just identify that order? What I find is that there is only a letter
There is an order by the
By this is Manish Chaudhary.
tendency of the petition shall not be the power. Order dated 17/3/23.
Order dated
17/3/23.
73/22. 23, okay. Seventy-three order says. Heard Ms. B. Chaudhary, counsel for the petitioners, and Mr. G. N. Saiwala, senior counsel so for the respondent ITC authorities. Mr. Saiwala, Leonard, senior counsel for the respondent IRCTC authorities has submitted that the petitioner in the red petition WBC 7624 of 2022 has in the meantime approached the respondent IRCTC authorities and settled the issues amicably. A copy of the letter setting so has been forwarded to the law officer IRCTC by the petitioner in WBC 7624 of 2022. Which Chaudhary and counsel for the petitioner has submitted that has yet not received any instructions in this regard and has sought for a week's time to seek clarification. It is.
Tendency of the,
Subsequent order.
it is observed. 17/3/23. It is observed that the pendency of this writ petition shall not be a part.
But withdrawing is not there. Order for withdrawal is not there.
No, withdrawal is not there, my lord.
Withdrawal is
Only,
not.
my lord, the tendency of the petition is not there to. Therefore,
Without prejudice to the convention.
Huh.
So this is not withdrawal as such.
We just have a copy of this letter by you.
He, in this thing, he sent me an email. I am not.
Apparently, because he, after this, he has sent an email to Mr. Chaudhary saying that he will not post the petition. So, Your Lordship, I think they have also they have settled the matter, no? There is no dispute so far.
It's okay, but
But Your Lordship is right, because they actually should have filed an application to withdraw. Or, but now I think she has received the SMS.
that letter is there. I'll just show it to you. And I have opened that page, that rule 68. For Ms. Chaudhary, that rule 68, you'll have to file an application, otherwise you'll find it very difficult. It's okay, in the meantime, you do it. We have this, we don't have any difficulties, but
No.
still,
Your Lordship can
Mhm.
take it that he is no more before Your Lordship. We will file that.
Mhm.
File that. Annex this letter and file it. So, regarding trains now, we are concerned with Krishna and
John Kumar Ghosh.
so they come, sorry, they come within that 211 category.
Yes,
Therefore, they have also paid for the first 6 months, so there is no dispute. But if we succeed on the submission in the event it is extended, we might get, if it is done within that period,
till November.
till November, we may get a benefit of that. That is the short term.
Okay.
Because this is really speaking not based on any duration thing. It was the objective situation prevailing, and they were making a prayer. They considered, they thought that for 1 year at least this method of payment can be resorted to, and that was allowed by 211/20. So these trains which they have ultimately got, and for which the first 6 months they have already cleared. If it is extended as per the prevailing practice within the year of till November, then they might get the benefit of
Okay.
installment. Otherwise, so that is in short the points, and it's a situation specific prayer and consideration by the competent authority, and a mode of payment concession for a year. Therefore, if this is granted by them, then there is no, it will be unfair to have a clause by which they withdraw that also. So, in my humble submission, that will be violative of Article 14, as well as the departure from the position, which Ramanna said you should not do. So this is the short.
And I have a list of books of Sampath Kumar, L. Chandra Kumar, Minerva Mills, Raj Restaurant, and Maharashtra Chess.
This is all right, don't, I keep things simple as far as possible. But, we can multiply, but ultimately the crux of the matter is this. So it's a question of whether your lordships think it is reasonable to depart after having given that concession for a year. And it's not a concession in terms of money, but only on a mode of payment.
Deferred payment.
Mode of payment. That is their concession. They are doing it, and respectfully submitted for a year. They could have continued that. It is arbitrary to give and then take it without reason. So, in my humble submission, that is not very fair, and it's acts of arbitrariness, which is violative of Article 14, and therefore. That's all.
And you have to also respond to their preliminary objection that the tender was floated at Delhi. So Delhi alone will have jurisdiction. That is one of the arguments.
Yes. With great respect, Millard, what I propose to do is, this was the position, Millard, when the Constitution started. This clause was not there about cause of action. And many Supreme Court in many decisions took the view that it is against Union of India, you can only move the Punjab High Court. At that time, the High Court was not there. Many High Courts took the contrary view, saying that this is not correct. Wherever cause of action is really. So this is very secondly summarized in Basu's book. I thought I'll make it a part of my argument and place it before your lordship, because I don't want to trouble your lordship with that. It is, so this is the page from Basu which we have taken. And this is about Article 226 is set out, and then he gives the that amendment came in 1963. Your lordship turn over the page, subsection 2. That became a constitutional amendment by which the cause of action thing, wholly or in part, was brought in.
which was not there in the earlier original constitution. That led to that problem. I just, part of my argument, I'll read this paragraph of this commentary. As a result of the view taken by the Supreme Court in so and subsequent cases, it was location or residence of the respondents which gave territorial jurisdiction to a High Court under Article 226. And the situs of the cause of action being immaterial for the purpose. The decision of the Supreme Court led to the result that only the High Court of Punjab would have jurisdiction to entertain petition under Article 226 against the Union of India and those other bodies which were located in Delhi. The object of Clause 1A, inserted by the 15th Amendment of 1963, was to restore the law view taken by the High Court and to provide that the High Court, within which the cause of action arrives only or in part, would also have jurisdiction to entertain a petition under Article 226 against the Union of India or any other body which were located in Delhi. The amendment thus supersedes the Supreme Court decision to the contrary. So that is the position, you know. That was what they are saying, that you have to only remove the Delhi High Court. That because the Union of India is issuing all these tender notices and the orders. That was the earlier position when the before 63 amendment. Now, my lord, it is a pan-India thing. All this is through this website. Tenders are floated. Anyone, anywhere, if he is eligible, he can apply. For example, a man from Guwahati can apply for Bombay. And similar things are going on. So it doesn't really matter. And these trains which they are getting, they are connected with our territorial part of Assam. All the trains which they are getting. So the question of, and they have their offices and other things, maybe from different other places. For example, Joyanta, he's a Karbi Alam. He's a resident of Karbi Alam, a voter here. And he has his organization in Calcutta also. And he is getting the train for Bombay, or he may apply for Madras. If he is competitive, he can get it. There is no problem on that score. Ultimately, it is the eligibility. If you satisfy the eligibility, anyone can do business anywhere. There is no restriction. So these people, when they have it, they will establish their own office and do the thing to carry on the business. Just like some of these people coming from here, they have their offices and then they organize and then they run the show.
No, online court proceedings. Online court proceedings now.
Everywhere. You know, somebody is arguing from London also. It can. Because I recall that famous song of the Beatles. Imagine a world without borders. There is a famous song written by which one? One of the Beatles. Right? Imagine a world without borders. John Lennon.
Now it has become a reality.
Now it is their reality. Exactly. So that should be a very technical point, you know. So this is my humble submission. Ultimately, my lord, how your lordship looks at that clause, and it's a 1-year thing. So if they get a relief for 6 months now. Already 6 months they have paid in spite of the interim order. If they are extended.
Well, here, Mr. Saiwala.
Yes.
This is some- This is, the 2020 13 SCC 285.
Maharashtra chess.
Maharashtra. Supreme Court made a distinction between the civil suit and a writ petition under 226. There are 10 millers at page 292. Which was a big case. There are 10 millers. There are 12. Not suppose 14. On earlier Supreme Court judgment. And the Constitution is equitable and discretionary. The power under that article can be exercised by the High Court to reach injustice wherever it is found. In fact, that is almost virtually mirrored. This is quoted from the Supreme Court 81. Justice Subarao. I personally think, my lord, that judgment really brings out the flexibility of the power under Article 226. And he said that our hands are long enough to reach injustice wherever it is found within our being. So,
Yes.
it's a very, very enlightening judgment. It's almost. I think that position is settled. Para 22 and 23 also. Okay. So these trains are flying within sun and have connection. These people who are getting through competition, they have their own establishment here to run the show. So the question of jurisdiction is really not an issue.
Well, here, Mr. Sahiwala then.
Yes.
Let. One of the, my argument is, my lord, that
Yes.
my lord, my first is, my lord, your losses may come to page 133.
133.
Yes. Oh, depends on the. It's not only a 713.
In which petition?
In this petition matter itself, 7138. My lord, your loss will find reference this office letter number so and so. IRMCA representation dated 27/9/22. This representation your loss will find at page 174. 174, my lord. I shall come to that later, my lord. Your loss is just. 174. Their affidavit, subsequent affidavit. Reference above. The loss is got it, my lord, 133. 133, my lord, first.
133 I've seen.
Yes, my lord. That, my lord, your losses may see, reference above IRMCA by depression number has requested to allow deposit license fee on quarterly basis for a period of 1 year for management of onboard catering services in train. The matter has been examined and it has been decided by the competent authority that all SBD, my lord, is in that bid document. The SBD is not here. The second one is long-term tender licenses, not long distance licenses, my lord. Long distance tenders. Long-term tender licenses shall be permitted to deposit license fee on quarterly basis for a period of 1 year. My lord, this
Yes.
long-term tender licenses. My lord, what happened earlier, my lord, as part of policy, they used to give it for 5 years, my lord. Give it for 5 years. That is the long term, my lord. And for 5 years, my lord, they have to pay 2 years, 1 year advance.
Yes.
Well, that clause, your losses may just see at page 233. My lord, I wanted to show your losses how it was. Page 233 of the affidavit.
233.
233.
Yes.
The last in 4.2 license fee B. In consideration of provision of the services and the bid submission of the licensee shall pay railway an agreed sum of rupees license fee for the entire duration of license payable on 2 + 2 + 1 yearly basis in advance.
So you are B, okay,
Yes.
4.2B.
Yes, 4.2B. In consideration of provision of services and the bid submission of the licensee shall pay the railway an agreed sum of license fee for the entire duration of the license payable on 2 + 2 + 1 yearly basis in advance. So earlier, my lord, they have to pay 2 years in advance, then 2 years in advance, then 1 year in advance. That was the my lord. This is the long-term license, my lord, as per the policy. my lord.
Yes.
My lord, earlier settlements were made, and during that period, my lord, COVID, from February 2020 to November 2021, my lord, there was no, my lord, catering, my lord, in the railway trains. Catering was stopped, my lord, due to COVID. From February 20, last part of February 20 to November, last part of November only they have started, my lord.
Yes.
So during this period, my long-term tender licenses suffered, my lord, because there was no catering during this period. So they submitted the repairs on which your lord will find at page 174.
Yes.
Now, this is Indian Railway Mobile Caterers Association. This is New Delhi. My lord, your lord is seen, my lord. It is their association address is at New Delhi. We are in association railway caterers who are engaged in the business of providing catering, so and so and so. Yes, well, this is not see. It is important to highlight second para, my lord. The IRC accepted our previous request wherein we were allowed to pay license fee on quarterly basis, 3 monthly installment. We appreciate the decision regarding health insurance. The partner mentioned that we have resumed providing catering services in trains after a gap of 20 months from 24th November 2021. However, we have been witnessing a thin footfall and a major dip in the number of passengers traveling in the train due to COVID and monsoon season. Resumption of business after COVID, the presumption of so-and-so board passenger fully changed. Not only the option which was introduced by the railway has made the business unsustainable. The accounts in the trains have gone below 50%, which is making business unsustainable. Important to mention that pandemic protocol so by this mention, my lord, they have prayed that they may be allowed to, because 1 year left, my lord, so they may be allowed to deposit the license fee on quarterly basis. And on that, depends on, my lord, they have taken the decision. This is on 2/11. So your lordship will see that 2/11 is the date on which this letter was issued. And this was also subsequently, my lord, preponed because this period of 1 year, which was given from 2/11, it was preponed from 2/11 to date of resumption of the catering service. That is the case, item number 14. Yes, that's the case, item number 14. I shall come later. So now, my lord, your lordship will find that so far they are concerned, this tender was opened on 9/11. You'll also find at page 19.
One nine,
No, yes, one line.
19.
One line. Annexure P1. There, the time of opening of the bridge is 9/11. And tenure you'll also find is 6. May be extended, may not be extended, because policy was not issued in this period. So that is why my lord they
You're getting a clear voice. You're getting a clear voice.
this.
I'm asking you, you are getting a clear voice? No.
No.
You are getting.
We are getting, madam.
Okay.
We are getting. Now you'll also find the tenure is 6 months. This tender was issued, my lord, after resumption of the catering service in the trains after about a year. When it was closed, my lord, due to COVID. In 2021, it was resumed. And this was issued a short tender, my lord, for 6 months, not as per the policy, my lord. And you'll also seen by page 26 that my learned friends press that the license fee is to be paid 6 months in advance. Page 26, note license fee payment. And your another clause is there at page 102. That also your losses may just see. 18.6. Now I shall place a few clauses, my lord, here. The we just come to page 47.
47. Page 47, last jurisdiction of the tender. The award of the license will be governed by the jurisdiction of the court situated in the state of Delhi. Clause is got it? Yes, page 47,
Yes, the last clause.
jurisdiction.
Then another clause, my lord, I shall place at page 53.
Page
53.
53.
Yes. 3.10 jurisdiction of the courts. Licensee agreed to submit all disputes arising out of or in connection with the bid documents license to the exclusive.
Just one, 53.
Hello?
Page 53, 53.
53. 53, clause 3.10, last but one.
Yes.
Similar clauses are there, my lord, at page 67 also, just your losses will note down, 3.20 also.
Second page is page.
67. The 64, sorry, I'm 60. 3.2.
Yes.
My lord, now I submit that, my lord. This is the independent tender. This has nothing to do with the data issued on 2/11, because the tenders were settled later on. And these are not long-term licenses, my lord. This is a short-term, 6 months only, which is mentioned in the letter at the 2/11. So they are not covered by this, my lord. That was issued for the days which are long-term licenses, and that was for period 1 year, my lord, because 1 year left, they were allowed to deposit quarterly. Here only 6 months. And a specific clause is there. The losses may rise, my lord.
I'll take a break and come back.
Fine. From the
Yes.
text pleaded petition is clear that NICO invoked the jurisdiction of Calcutta High Court on the plea that part of cause of action arising within the territorial jurisdiction. According to NICO, it became aware of the contract proposed to be given by ONGC on reading advertisement which appeared in the Times of India at Calcutta. In response thereto, it is submitted the bid or the tender from Calcutta office and revised the rates subsequently. When they learned that it was considered ineligible, it sent repression including text messages so and so, New Delhi demanding justice. As stated earlier, the steering committee finally rejected the offer of NICO and awarded a contract so and so. And we can skip over, my lord, this part. This is their environment. Then 13-15, my lord. Paragraph 13. The submission of the learned counsel for a NICO based on the section 21 of the Code of Civil Procedure that even if the court comes to a conclusion the High Court of Calcutta has no jurisdiction, this court should, in absence of the proof of prejudice, refuse or interfere with the decision of the High Court unless it otherwise found to be erroneous, while the spirit of section 21 of the Code of Civil Procedure may support such a submission. We are afraid of the discretion cannot be used in favor of a party which deliberately invokes the jurisdiction of a court which has no jurisdiction whatsoever for ulterior motive. That would only encourage such type of litigation. The object of underlying provision of section 21 is not to encourage such litigants to avoid harassment to litigants who have bona fide and in good faith commence proceeding in court, which is later found to be wanting in the jurisdiction. In the instant case, we are convinced that doubt that NICO did not bona fide involving the Calcutta High Court, and therefore the submission of so and so in the appeal, my lord. So this was the, my lord, because they ever that they came to know from paper report and other things, my lord. Now, the second case, my lord, I placed 2 paragraph only, 25 and 37. There are many decisions have been referred to here, including so ONGC, my lord. This should call also. Paragraph 25 is at 44, my lord.
Yes.
The learned counsel for the response referred to several decisions of this court and submitted that whether particular facts constitute a cause of action or not must be decided on the basis of the facts and circumstances in each case. In our judgment, the test is whether particular fact of the substance can be said to be material, integral, or essential part of the lease between the parties. Well, this is very important, my lord. What I'm saying. If it is, it forms a part of cause of action. If it is not, it does not form a part of the cause of action. It is well settled that in determining the question, the substance of the matter and not the form thereof will be considered. And I shall not discuss my lord, because other things are there. There are 37. At page 346. From the aforesaid discussion and keeping in view of the ratio laid down in a catering of distance of this by this court, it's clear that the purpose of deciding whether facts averred by the appellant prisoner would or would not constitute a part of cause of action, one has to consider whether such fact constitute material, essential, or integral part of the cause of action. It is no doubt true that even if a small fraction or cause of action arises in the jurisdiction of the court could have jurisdiction to that in such situation. Nevertheless, it must be part of cause of action, nothing less than that. So, my lord, here my submission is this, my lord. No part of cause of action arose here. Now, in this case, my lord, the tender itself, my lord, at several places it was written that, my lord, only court at Delhi will have jurisdiction. My lord, in this regard, I shall rely on two judgments, my lord. 2013 9 SCC, there are page 32, and 2020 13 SCC, page 285. 2013 9 SCC, my lord, page 32.
33.
32, my lord, and 2020 13 SCC, page 285.
Two.
I'm just giving that two versions, my lord.
What is the last citation? 2020 13 SCC page?
2013 SCC, 9 SCC, page 32, my lord.
No, that is first. Second
First,
is 2020.
Second one is 2020 60.
16 SCC. Page?
Oh, I'm sorry, I'm sorry, my lord. No, 13 SCC. I'm sorry. I'm sorry, my lord. Yes, 13 SCC.
13 page?
13 SCC, page 285, my lord. I'm sorry.
285.
That is for other. 16 SCC is for different purpose, my lord. 285. My lord, in the first case, my lord, I shall rely on 2-3 paragraphs, paragraph 32, 37, and 57. 2013 9 SCC, paragraph 13, paragraph 32, 37, 57.
Para 30.
32, 32, 37, and 57.
32, 37, and 53.
Hello?
32, 37, and
53, 57.
57.
37, 32, 37, and 57.
57.
That, my lord, in fact, your lordship has dealt with, my lord, while dealing with jurisdiction matters actually. So, the exclusive, my lord, word is there, my lord. Your lordship may just come to paragraph 57 only, my lord. I think your lordship may deliver judgments on paragraph 57. is there. The conclusion, my lord. The other. For the reasons mentioned above, I agree with my lord whether that the clause given the absence of the words like around only exclusive or exclusive jurisdiction neither decisive, nor does it make any difference in deciding the jurisdiction of the court. The very existence of jurisdiction clause in an agreement makes it intent to the parties to an agreement quite clear, not advisable to read such clause in agreement like in the present case, only the courts at Calcutta had used it to accept dispute between that party. Hello, the earlier exclusive words would have been there, but subsequently the Supreme Court has changed the same. This
Yes.
is, my lord, normally for the civil courts also. But whether in the read court also, my lord, this should be considered, my lord, that I shall rely on the second judgment. 2020-13 SCC page 285. Here, my lord, I shall rely to paragraph 24 to 27. Last three pages, my lord. My lord. At this juncture, to what discussing the decision of this court in Aligarh Muslim University at so. In that case, contract between the parties contain a clause conferring jurisdiction on the court at Aligarh. When the High Court of Calcutta exercised jurisdiction over the matter, this court held that we are surprised not a little that High Court at Calcutta should have exercised jurisdiction in a case where it had absolutely no jurisdiction. The contracts in question were executed at Aligarh. Construction work is to be carried out at Aligarh. Even context provided that in the event of dispute, the Aligarh court will have jurisdiction. The arbitrator was from Aligarh and was functioned there merely because the respondents were Calcutta-based armed. The High Court of Calcutta seems to have exercised jurisdiction where it had none by the adopting a crude line of reasoning. We are constrained to say that this is a case of abuse of jurisdiction, and we feel that respondent deliberately moved the Calcutta High Court, ignoring the fact that no part of cause of action has arisen in the jurisdiction of the court. It clearly shows that the litigation filed in Calcutta High Court was thoroughly unsustainable. The court examined the facts holistically, noting the contract was executed and to be performed in Aligarh, and the arbitrator was to function at Aligarh. It did not consider a contract conferred jurisdiction on the courts at Aligarh. But this was one of the factors among the several other considered court in the determining the High Court of Calcutta did not have jurisdiction. In the present case, Bombay High Court relied solely on clause 21 of the Constitution and bylaws to hold that its own jurisdiction is ousted. The Bombay High Court failed to examine the case holistically and make a considered determination as to whether or not it should in the exercise its power under Article 226. The scrutiny to be applied to every writ petition under Article 226 by the High Court is a crucial safeguard of the rule of law under the Constitution and 11 territorial jurisdiction. Not open to High Court to abdicate this responsibility merely with the existence of privately negotiated document ousting the jurisdiction. It's certainly open to the High Court, my lord, decision to take into consideration the fact that the appellant and the second respondent consented to resolve all the legal disputes before the courts at Chennai. However, this can be a factor within a broader factual matrix of the case. The High Court may decline to exercise jurisdiction under 226, invoking the principle of forum non-convenience in an approved case. The High Court must look into the case of the appellant holistically and make a determination as to whether it will be proper to exercise that situation. We do not express any opinion as to whether the factors should be considered by the High Court in the present case, nor the corresponding gravities that should be accorded to such factors. Such principles are well known to the High Court. It is known for this court to interfere the discretion of the High Court in determining when to engage in this jurisdiction, unless exercised arbitrarily and whole absolute reliance for the Bombay High Court on clause 21 of the Constitution and the bylaws determine the jurisdiction under outstate, however, one of such instances. Accordingly, allow the appeal and set aside the intervention. So this is one of the factors, my lord, which should be considered, because these clauses are there in the tender itself, and the parties participate in the tender, my lord, look in the clauses, and they got the tender, my lord. Work, they got the work.
But you have to explain this,
My lord?
this para 26
Yes,
says both ways.
yes. My lord, I am placing that, my lord, but only thing, my lord, the Supreme Court says that this should be one of the factors to be considered.
No, because it says, it also says that it in its discretion exercise power.
Yes, Well,
Therefore, once it's a question of discretion,
Yes.
That is not solely the cause of action.
No, no, I'm
The
not saying
holistic
that, my lord.
approach.
This is one of the factors to be considered in the broader facts of the case. My first submission, my lord, that no part of project arose at in the jurisdiction of this court.
I'm just trying to understand your argument with one which
Yes.
is made by Mr. Goswami. You see, if a train operates within the jurisdiction of Northeast Frontier Railway, number one. And second is that if one of the petitioners is a resident of the state of Assam. and
My lord,
they take
he
a-
is not the tenderer. He is not the tenderer. Petition number 2 is not the tenderer.
He is not the tenderer.
No.
Okay.
It's a petition number 1. The company is the tenderer. He got the. Petition number 2, my lord, only become a party. My lord, he is a maybe a my lord, they have not mentioned here. He may be a director or shareholder or director of the company. Petition number 2 is not tender. And so far, this first petition is concerned Gitanjali Express. Gitanjali Express, that is from Kolkata to Mumbai. Thirdly, my lord, second part argument, my lord, that they have participated in the tender. Looking at the tender conditions, payment terms, and when they got the, my lord, the award, thereafter they cannot challenge the terms of the tender. In this aspect, my lord, I shall rely on this one judgment, my lord, that is Mirat Development Authority. 2009 6 SCC. Two 2009 6 SCC, page 171.
2009.
9 SCC, 2009 6 SCC, 171. 171. Only 2 paragraphs I am relying on, my lord.
2009.
Paragraph 26 and 27. At page 181.
Yes.
My lord, the tender is an offer. It is something which invites and is communicated to notify the acceptance. Broadly, it is stated, it must be unconditional, must be in proper form. The person by whom tender is made must be able to and willing to perform his obligations. The term of invitation to the tender cannot be open to judicial scrutiny because the invitation to tender is in the name of contract. However, a limited judicial review may be available in cases where it is established the terms of the invitation of the tender were so tailor-made to suit the convenience of any particular person with a view to eliminate all others from participating in the bidding process. Now, third one. The bidders, there are 27 minutes. The bidders participating in the tender process have no right.
Please
Bidders possess no other right except the right to equality and fair treatment, the matter of evaluation of the competitive bids offered by the interested persons in response to the notice inviting tender in a transparent manner and free from hidden agenda. One cannot challenge the terms and conditions of the tender except on the above stated ground and the reason that the terms of invitation of the tender are in the realm of contract. No bidder is entitled as a matter of right to insist the authority inviting the tenders to enter into further negotiation unless the terms and conditions of notice so provided for certain. So, they have submitted the tender and they got the award, and after that, my lord, they cannot challenge the terms and conditions of the tender. That other decisions, my lord, my learned friend is, all decisions are, my lord, mostly referred to in that last decision, 2020 16 SCG 759, my lord. Bharat Coking Code.
Thousand
2020 16 SCC 759. 759. I shall place only 3 paragraphs, my lord, because all decisions referred to here, the Jagdish Mandal and Tata Steel are every, my lord, Ronak, everywhere, all decisions. Page para 32. 2020 16 SCC, page 759.
paragraph.
32, 32 to 34 and 47. It's 4 paragraphs. So the Jagdish Mandal has been referred to here, paragraph 32, page 771.
Yes.
Judicial review or administrative action is intended to prevent arbitrariness, irrationality, ungenuineness, bias, and malafide. Its purpose to check whether choice or decision is made lawfully and not to check whether choice or decision is sound. When the power of judicial review is invoked in the matters relating to tender or award of contracts, certain special features should be borne in mind. A contract is a commercial transaction. Evaluating tenders and awarding contracts are essentially commercial function. Principle of equity and natural justice stay at a distance. If the decision relating to award of contract is bona fide and in public interest, the courts will not exercise the power of judicial review, interfere even if procedural aberration or error in assessment of the previous to tender made out. The power of judicial review will not be permitted to invoke to protect the private interest at the cost of public interest or to decide contractual dispute. The tender or the contractor with a grievance can always seek damages in civil court. Attempts by successful tenderer with imaginary grievances, wounded pride and unsuccessful tenders with business rivalry to make mountains of molehills of some technical procedural violation or some prejudice to self persuade the courts to interfere with accessing judicial review should be resisted. Such interference, either interim or final, may hold up public works for years or delay the relief and support thousands, millions of people. And such conscious restraint is also necessary because judicial intervention by itself has effects of time and money, which is unchecked would have problematic ramifications on the state's ability to enter into contracts and trade with private negligence. Further, it is not desirable or practical for the courts to review the thousands of contracts entered into by the executive authority every day. Courts must be cognizant that often at times private interest or a few can clash with public interest of the masses, hence requirement of demonstrate effect the public interest has been qualified. It is thus imperative that in addition to arbitrariness, illegality, or discrimination under Article 14 or encroachment of freedom of Article 91G, so and so, to is demonstrate that remote report remedy is sought. Although thousands for the latter it is not right, but it is nevertheless essential to prevent the bypassing of the civil courts and use of constitutional avenues for enforcement of constitutional rights. Then my lord, 47. Even if there has been, para 47, my lord says, even if there has been minor deviation from the explicit terms of the NIT, it would not be sufficient to itself, absence of Pella Ferry for the courts to set aside a tender at the behest of the answer. I mean, this is not. Okay. So, my lord, my
This, I always a question to myself,
my lord,
whenever this whenever this Jagdish Mandal is cited,
yes,
I always put a question to myself. That in case like this, how can the petitioner, in this case, let us see, how can in this case the petitioner will structure his case for damages and compensation? Because this case will not fall in any of the categories permissible for claiming a damage.
that may not be, my lord. That's another aspect. But only thing, my lord, what I am submitting, my lord, that the data under reference, my lord, which they have made, that is not for them, my lord. That is prior to the settlement of the tenders, opening of the tenders, my lord. That has nothing to do with the new tenders. And they, with their open eye, my lord, participate in the tender with the clauses that they have to pay 6 months in advance. Because earlier, my lord, in long-term context, 2 years advance it will be paid. 2 years, 2 years, 1 year. So now, my lord, only 6 months, because this is short-term tender has been issued, because no new policy has been issued by the IRCTC, my lord. They issue policy from time to time. And secondly, my lord, I have said, my lord, that point of jurisdiction also, no part of cause of action in the writ petition, not a single word, my lord, that for any cause of action arose here. Not. And they have challenged the tender in respect of Gitanjali Express, my lord. Which is also. And thirdly, my lord, this 211 notification, this letter, that has also been modified, my lord, later on, which you will also find, my lord, in the second case, Isna Enterprise, where, my lord, the division bench disposed of the appeal. You will also find. First case, my lord, 7113. Here, my lord, double 171 of 23.
Double 171.
No, sorry, double 171.
Yes.
My lord, that letter has been again modified, my lord. You'll also find at page 20.
Page 20.
You'll also got it.
Yes.
Hide above referred letter number 2 to 4, the Jones have sought clarification with regard to direction submissions of quarterly license fee by the licensees of SBD and long-term tenders as per corporate office letter number 21122. The matter has been examined and it clarified that the above relaxation for submission of license fee on quarterly basis was permitted only for 1 year from the date of resumption of the cooked food post COVID-19. So this that letter has already been expired. Term has already been expired. And there is no stay order, my lord. In this case, my lord, one interim order was passed, allowing them to deposit 3 months life. But this has already been given effect to South India, my lord. No other any case here, except this. Because 1 year from the resumption of cooked food, my lord, it is from November 21, my lord, last part of November.
From November 21, you
Last part of
resumed
November.
cooked food.
My lord,
From November 21, you resumed cooked food.
yes. they have said here also, my lord, in this case. My lord, in this case, your lordship may just see para 11. At page 7,
Just a moment.
para 10 and 11.
Something is wrong.
My lord,
Something is wrong. When did you say your cooked food resumed?
cooked was resumed, my lord, up in the last part of November 21.
Could not be, because your policies of 2/11/22.
I know that was,
That was
in
prior
fact, my lord, that was, my lord, correct. But that was issued from that date for 1 year, but that has been preponed, my lord. Preponed. If you'll also see, my lord, in para 10 and 11 of this petition, they have said so. Maybe said the operational Pentica services come to a grinding halt after the outset of COVID pandemic from 25th March 20. This had continued till 19 November 21, when the long gap of 20 months, the Pentica services together with other mobile catering services resumed. Suffice it to state that pandemic had created such havoc across the globe and in India that it has disrupted
So
normal
this
life.
this
and
has to be
regular-
read as if not because of even if you accept your statement
Yes.
that the resumption of cooked food was in November 2021, these letters will have to be accepted as if the authorities have knowingly taken a decision to exempt for a year.
Yes, that was Malad preponed letter. That was preponed. Malad, and moreover, here,
No, but preponing is not here.
that is there, Malad. That is the page 20. Page 20.
It cannot be. You see, there's a reason why. This page 20 letter is of 3/2/2023. They say now resume. So it is prospective. It can't be retrospective.
No, Malad, that has been given, my lord. That is,
But doesn't make a sense.
my lord. That because they say 1 year from the death, my lord. This I have challenged on the ground, my lord, that they are not SBD and again, my lord, same thing. SBD and long-term licenses. So they have no right to challenge this, my lord. Because whatever
No, I couldn't follow you, Mr. Saiwala. Please repeat again what you have said.
I am saying, my lord, this first argument I have advanced in the earlier case, that was meant for only SBD and long-term tender licenses.
SBD means Shatabdi.
No, state, my lord, it's not big document, that is separate, my lord, not here, it's here. And long-term tender licenses, my lord,
Okay.
long-term, 5 years. My lord. That was applicable. And here, not a single person is there, my lord, who is long-term, my lord. They are only getting this 6 months tender, my lord. All tenders, my lord, submitted in the affidavit, my lord, later on. In the additional affidavit, my lord, that these are all, my lord, of 6 months then. If losses takes up, my lord, there are 2 affidavits dated 23/23 and 25/4/23. They have annexed some of the, my lord, orders.
No, I think Mrs. Haiwala,
Yes.
uh, what Mr. Goswami was submitting,
Yes.
it makes more sense than more acceptability than what you are saying, because of the reason you come to page 24 of this writ petition,
24 of this.
1171.
Yes. My lord.
Now you see, this is 19/11/2021.
Yes.
The cooked food is resumed,
Yes.
correct? So what they do is by 24, they are revoking their 23 to 21 letter by which all contracts were terminated.
Yes.
So you see now what Mr. Goswami was saying, it makes sense because of the fact that, and more acceptability, because of the fact that after they were suffering for 20 months, then the authority said, okay, your license fees, we defer it. It will be deferred payment. So we understand that. So there cannot be an issue of preponement.
My lord, why I'm submitting, my lord, because only 1 year left, my lord. So 1 year, my lord, virtually this long-term licensee are no more, my lord.
No, that is okay.
That is. So, my lord, my humble submission is this letter, my lord, 211 or subsequent letter does not apply to the petitioner.
That argument is okay.
Yes.
But
Yes,
to
my
say
lord,
that there was a
that's
preponement,
the main
I
argument, my
find
lord.
it very
That's the main
difficult to
argument.
accept.
And your lordships may just see, my lord, there are two affidavits. They have annexed some of the awards, my lord. Page para 23, my lord, one affidavit was filed.
In which writ petition?
In this petition, page 39, my lord, page 39. Page 39, my lord.
Yes.
Yes. This is the, my lord, Krishna Enterprise, UP.
Yes.
Award of temporary license come commencement of onboard catering service number so and so Mahananda Express. My lord, it is Mahananda Express somewhere else.
No,
Not-
just I'm not following you. Which page?
Page 39.
39. Eighteen 11/22.
Yes, 181122.
Yes.
These are all, my lord, temporary license. Similarly, page 40 also. Temporary license. It is Guwahati J Lohit Express. Then 31/123, page 41 also. 41 is a different place, my lord. It has nothing to do with Guwahati. Forty-two, you will also find. This is Delhi Humsafar Express, my lord.
Yes.
These are all, my lords, temporary licenses, my lord, 6 months. So it has nothing to do with the, my lord, long term. So they have no, my lord, locus, my lord, to tell this later. And this has already given effect to, my lord. And the last one is also, my lord, similar. 17 also. Similar to this one. Last one. Deepak.
In one of the, because Mr. Saiwala,
Yes.
they will need some support for a different reason. In some of the, in one of the tender document, I was reading the food items. There's a description given, which I don't know. I won't recall.
Yes.
In one of the tenders,
Yes.
there's a list of items to be supplied.
Yes.
I found that in one item, there was a price tag of 20 rupees for 2 samosas. Correct. I prefer samosa of one of the restaurant in Fancy Bazaar, where each samosa is 18 rupees.
Yes, it is 18 rupees, 15 to 18, my lord. My lord, but in the railway, my lord, the wholesale, my lord, and size is also.
It's
slightly-
okay, but when I look at the platter, you see the chola bhatura. Somewhere it is given, the quantity is, price is 50 rupees. 50, 200 grams of chola. 200 grams of chola would be, I think, not less than 100 rupees a kg. I don't know the price.
More than 100.
Huh?
100, around 100.
So 200 rupees. I don't know how they manage.
With liquid and masala and everything. my lord.
So perhaps that is why, going by train, I always prefer my own food. Okay. That's all.
My lord, this last one, my lord, yours. My lord, this Deepak and company, my lord, 1841. 1841 the case, that is same, my lord, as 14. Same as 14.
Very good.
That is same as 14, my lord.
Same issue, same.
That is the deponing of the, my lord. labor.
18 is same as item 14.
14 and 17 same.
One issue just
No, 14 is 18, 14 and 18 same. Yes.
Please give me my writ petition number, because I won't remember my numbers. This
first
is
one is, my lord,
1841.
1171-23,
1841
1841.
is same as 1171,
yes.
and
These two,
only these two are.
Yes.
Okay.
and other three are same, my lord.
Okay.
Other three are same. So that is the main, my lord, that they have no locus, my lord. Challenge it, because they are temporary license. Much-
Temporary means 6 months.
6 months.
Okay.
6 months only. And that's said for 1 year only, my lord, because that was for 1 year. Then less last month for part. That is why it was said 1 year.
Okay.
May I please? I'll very briefly deal with the submissions. Sir.
Yes.
First thing is, Milord, that is a long-term things or not really therefore indicated, Milord, the traveling time and the total distance. Two charts we have given. The ones we have got time of traveling time, all these are long distance trains. There is a difference between the long distance licenses and, my lord, the period, duration. Duration is one thing. You can have a long distance train. You can have it for 5 years. You can have it for 6 months. That is your discretion. And as a matter of fact, last time when he argued, he mentioned that also, I remember. Under the 2010 policies, these long-term trains were, tenders were invited and they were given, and there was a period prescribed in the 2010 policies, and accordingly, the trains were settled for that period. Normally, it was, I think, five years plus 3 years, 5 years, 5 years, and 2 years. Now, in 2017 policy, that has come down to 5 years plus 3. Huh? No, but 3 years they can extend. But 2017 onwards, even before COVID, they have stopped issuing the tenders for long terms. Therefore, this method of 6 months plus extendable by 6 months came into the picture, which is being now continued also. So they have not issued any tender for long-term. These are long-term trains, but the period is short-term, 6 months, 6 months. Earlier, 2010, they used to float tenders, and it was for a long term, 5 years, 3 years, 2 years. 2017, it came, but they have not issued long-term licenses. The duration has come down, the distance remained the same. Therefore, this argument of long-term licenses, that will only mean when your duration is 6 months, 6 months, the distance which is covered. If it is a long-term train, long-distance train, you are a long-distance licensee. But your duration is less. So that distinction is important. Because 22, that 21122, which is at page 93 in 7597, if your lordship is having that file. On which reliance was placed. Representation has been requested to allow deposit license fee on quarterly basis for a period of 1 year only for management of catering service in trains. The matter has been examined and has been decided by the company. All FBD and long-term tender licenses, all this Rajdhani, Shatabdi, and all that stuff, deposit quarterly for a period of 1 year. So the licenses are referred to as long-term licenses because the distance is long-term trains. But the duration is shortened by 6 months and 6 months. That's the difference. Therefore, it will be incorrect to say that these licenses are not long-term licenses. They are long-term distance trains licenses. So that is one. Then the catering from Cook Food. Your lordship is absolutely right. That date is 19/11/21 when Cook Food was introduced. Because for a period after reopening the railway, they were not allowing cooked food to be given. Therefore, everyone had to take their own food. So this was brought about by this document 19/11/21, which is at page 24, he relied on in that writ petition number 1171.
1171, yes.
He relied on that page 24. That came, your lordship was pointed out that fact. It came 1 year earlier to the order we are concerned. That is 1911-21. This concession which has been given after the trains started operating and the 2/11/20. So it can be possibly from that date.
In fact, the railways would have to take, the railways, they are required to take a call. In fact, they'll have to investigate any train outgoing from the state of Assam or incoming into the state of Assam
Yes.
for a particular period of time. The pantry doesn't work. There's a distance everybody knows, nobody wants to say. For the entire period when the train travels through West Bengal, the pantry is not allowed to operate. There'll be only the street vendors who will come in and sell. The pantry people are beaten up, thrashed. So they will not operate their catering in the state of West Bengal.
So that the long-term thing is just, it doesn't hold any water because the order itself is giving a concession for all these long distance trains, for which they have reduced the period to 6 and 6. That is the first argument. Then it is said about the jurisdictional part. Jurisdiction, in these sort of cases, as I have stressed before your lordship, the amendment that cause of action wholly or partly arises. Now you float a all India tender, pan India. It's a pan India organization. You float a tender giving details and all that, eligibility and all that. Anyone having this business can apply. Where will he apply from? He will apply from the place where he is posted or is staying or he is going to do business. So he may select his own trains. If he has that, if he is a resident, all and good. If he is otherwise in business here coming from a distant place, that also is good enough for a cause of action. And both Jayanto and Krishna, your lordships can note down the paragraphs below. In Jayanto's case, we have mentioned specifically about his location here and all that. That is in writ petition 7597, in paragraph 7, page 7.
In writ petition number
7597 of 22.
para 7.
Para 7. Page 7, I'm sorry, page 7. And so far Krishna is concerned, that is writ petition 7624, para 6 and page 6. We have said that he has stalls, others, office, everything here, paying GST here. So he may be a man coming from outside Assam, but he has business here. Apart from the trains, he has other railway stalls and other things. But he is having selected trains which operates from Assam and comes into Assam. So that is all that is required, nothing beyond that. It's an all India affair, so you have a right to choose where you start your business from. So cause of action, you have to view in that context. So that is so far as that cause of action thing is concerned. And secondly, Your Lordship has seen that judgment. It's a basic structure of the Constitution now, 226. Even statute cannot take away that power. What happened to that original act without creating this administrative tribunals? Clearly, those clauses excluded High Court. Therefore, the Supreme Court said it will be unconstitutional. Can't take away the power of the High Court. That was the first case of administrative tribunal.
L. Chandra Kumar.
Chandra Kumar came.
L. Chandra Kumar. L. Chandra Kumar. L. Chandra Kumar.
Yes. And that your Lordship has already seen that judgment. So, this is the jurisdiction of the High Court, a constitutional jurisdiction. It can't be taken away even by statute. That is the law. Therefore, to say that High Court will have no jurisdiction in the matter of in relation to a train which is operating through Assam or from Assam or coming to Assam by a person who is an Indian citizen, having his establishment here and having succeeded in getting the settlement to operate. That will be absolutely unthinkable in the constitutional sense. What is the cause of action? Bundle of facts. A train goes from here or comes from back to here, and you are operating that train. You are a person either from this place or coming here and residing and having an office to start your business here. What is the problem? There is no problem about that cause of action thing. And then, my lord, the cannot challenge the terms. Now, my lord, what are we challenging? We are not challenging 211, 22. That's the decision of the railways, competent authority, that yes, this is a situation where we should give some benefit to those who are in operation. And they say, okay, to pay in quarterly installments for a year only, indefinitely. Therefore, there is a purpose in doing that. They take the overall situation post-COVID, the representation, and they know the plight of people. Therefore, they think that yes, for a year, we should get it to installment instead of the whole amount in it. That's the simple thing. And now your tender itself is departing from that. When that is in operation, how can you depart from that? That is where the question of Article 14 comes in. Ex specie arbitrary. And if it is so, then we have every right to move the High Court. That gives us the cause of action.
We'll continue to.
Listen.
Nowadays, my lord, best kitchens are provided. That is why best kitchens. They have to give best kitchens.
Okay.
My lord, some places, my lord, they have to have a bigger kitchen, good quality, my lord, they expect. Because in the train, my lord, it cannot be done for so many persons. In train, one unit, my lord, they cannot be done.
No, there's a different problem. It's a law and order problem. In West Bengal, it's a law and order problem.
Best kitchens are now given.
They will not allow it to you, but anybody to do it. You can just ask your people, they'll tell you.
Anyway, that is not the question
No,
here,
no,
but
that-
only
but
your
still-
losses said, my lord, that
But
expensive
still-
cars are not
But still these caterers from Northeast will have to have a separate, what you call, consideration, because no other places they have this restriction. You'll know, once you board the train, you'll understand.
My lord.
Is that till Kathiar it is disturbed in Rajdhani. Even Rajdhani they don't operate. During a particular tenure, they will not operate.
That I have already placed below, your lordship has seen that. Because it is, even by statute, it cannot be taken away. It is the administrative tribunal judgment, the first judgment, voting judgment. And another I will cite Milos 97 3 SCC 261. The 7-judge bench, Milos Chandra Kumar. Para 99, page 311. It is also relating to that administrative tribunal, you know. Para 99. In view of the reasoning adopted by us, we hold that clause 2D of Article 323A and clause 3D of Article 323B to the extent they exclude the jurisdiction of the High Court and the Supreme Court under Article 226, 227 and 32 of the Constitution are unconstitutional. Section 28 of the Act and the exclusion of jurisdiction clauses in all other legislation enacted under the aegis of Articles 323 and 22(3)b would to the same extent be unconstitutional. Jurisdiction conferred upon high courts under Article 226, 227 and upon the Supreme Court under Article 32 of the Constitution is a part of the inviolable basic structure of our Constitution. While this jurisdiction cannot be ousted, other courts and tribunals may perform a supplementary role in discharging the powers conferred by Article 226 and 227 and 32 of the Constitution. The tribunals created under Article 323A and B of the Constitution are possessed of the competence to test the constitutional validity of statutory provisions and rules. All decisions of these tribunals will, however, be subject to scrutiny before a division bench of the High Court, within whose jurisdiction the tribunal concerned falls. The tribunals will nevertheless continue to act like courts of first instance in respect of the areas, and then the appeal lies here. But this is what the Supreme Court has said with regard to the basic structure of the Constitution. There is inviolable. And one more paragraph, if I may just go to your lordship, at page 262, my lord, the head note is good enough. Broadly speaking, judicial review in India comprises three aspects: judicial review of legislative action, judicial review of judicial decisions, and
This you are reading in which paragraph?
Lord, I am just at page 262 from the head note only I am reading. It summarizes several paragraphs quite accurately. Page 262. Lord.
Yes.
Broadly speaking, it starts like that. Broadly speaking, judicial review in India comprises three aspects: judicial review of legislative action, judicial review of judicial decisions, and judicial review of administrative action. Herein, we are concerned only with judicial review of legislative action and of judicial decisions. The judges of the Superior Court have been entrusted with the task of upholding the Constitution, and to this end have been conferred the power to interpret it. It is they who have to ensure that the balance of power and wishes by the Constitution is maintained, and that the legislature and the executive do not, in the discharge of their function, transgress constitutional limitation. It is equally their duty to oversee that the judicial decisions rendered by those who ban the subordinate courts and tribunals do not fall foul of strict standards of legal correctness and judicial independence. That is all. That is now a settled proposition that this High Court's power is a part of the basic structure of the Constitution, and therefore it can't be ousted by an agreement clause saying that all disputes will be in courts in Delhi. That doesn't include the constitutional power of the High Courts. And if the cause of action arises, every High Court will have its choice. As far as that is concerned, I have already indicated the paragraph where we have stated, which clearly indicate, and the trains which have been given on competition to us also, my lord, have apply through the state, either originates or comes back. So therefore, there is no problem with regard to question of any.
Just a moment, I'm trying to show you something.
Yes, my lord.
Since you're in that L. Chandra Kumar,
Yes.
this High Court rules I am showing it to you.
Yes.
This has defined what is superintending jurisdiction, correct? In page 397, you will find the list of tribunals over which we have superintending jurisdiction. Interestingly, Central Administrative Tribunal is not under the superintending jurisdiction. So we are following it because of L. Chandra Kumar. But-
Because appeal is provided now to the High Court under that act.
But-
Administrative tribunal.
Correct, but otherwise superintending jurisdiction, the question arose here, whether the superintending jurisdiction of the existing high courts can be taken away. That was the issue, how it started. But insofar as our court is concerned, it was never brought in under the administrative control.
Guwahati High Court Superintendent of Tribunals. This is 92.
Just for academic purpose, no other purpose.
Yes.
But the question arose about the superintending jurisdiction being taken away because of the establishment. Once it is never there, we are still following it, but
But Milord, if I remember correctly, there is a separate provision providing for an appeal.
no, that is okay.
So your lordships have a wider field of superintendents by way of appeal.
So that is why read petitions are being entertained. Not as
That
not as an
was,
appeal.
That was sought to be eliminated earlier. So the first case dealt with that you can't take away the power of the High Court.
Huh.
Therefore, the appeal provisions they suggested and then it was amended and brought it.
Just a background because you don't have that jurisdiction.
Possibly.
Only academic part, nothing to do with your matter.
Yes,
But still,
quite similar.
because this L. Chandra Kumar says that we have the superintending jurisdiction.
Correct.
So now it was required that we amend and bring it.
I think your lordships may do this in view of what was said by, in two cases. The first case of Sampath Kumar.
Sampath Kumar and then
and
this.
the second Chandra Kumar. No? The lordship can consider that because superintendence is a slightly different field also. Appellate power is with regard to the decision making. And this will be something in addition. You know,
In addition.
Superintendent.
It opens up scope for 227.
Yes. Sure.
That's all I think.
That's all I think. I have covered. That's all means same thing, basic structure of the constitution. I think don't have to multiply that you well know. So I think I have. I think I have covered the points raised by my learned friend. In these two cases, really, do not touch the point where we are concerned, decided cases on cause of action. I don't want to argue with your lordship about cause of action. I leave it to your lordship's
ABC laminate.
So far the cause of action is concerned, as I have said, that you have to take a wider view of this thing. Because the Indian Railways is an all India phenomenon. The tenders are all India phenomenon, and people are interested yet for different locations, and they are entitled to come and do business everywhere. That is guaranteed by the constitution. So there is no problem about that. So you can't oust them because of cause of action. And I think, I have covered. Huh?
Mr. Goswami, you will be here next week also,
Yes.
because I'll be fixing this matter for clarification, if any, on the next week. Because this weekend I am traveling. I'll not be able to,
I'll be here. No problem.
I'll not be able to deliver the order.
No, it's all.
So that's fine.
It doesn't matter.
Uh,
Because it is really, in a sense, it is academic, but in a sense also relevant, because railway policy has been now 6+6. They are not going for the long term. Particularly, even before COVID, I am told this has started, and now it is being continued. Therefore, and our thing is only up to November of this year. So if we get some concession also, that is good enough. Otherwise, it has no that way very long repercussions.
I'll fix for on 7th of June for clarification, if any, because I'll be intermittently traveling.
At your lordship, please.
Uh,
Deeply obliged.
Mr. P.K. Goswami, the senior counsel, assisted by Ms. D. Chaudhary, the counsel for the petitioners, as well as Mr. G. N. Savala, learned senior counsel, assisted with Mr. A. Annexing, annexing, counsel for the respondents. So the argument is completed. Judgment, what do you call, a list on 7/6/2023 for clarification, if any.
Hello, only thing, your losses may just note down the pages, my lord, in the other two cases, 7597, the three contracts they have annexed, 173 to 176.
Just a moment.
These are 7597.
Oh, no.
And it's a K. Kohli, 173 to 1.
Just a moment.
These are claims from outside. My lord.
Which writ petition? Which writ petition?
And in the other case, my lord, they are not placing for classic. The Krishna Enterprise, my lord, that is in 7624. It is 163 to 166.
This is in one matter. The other matters also, please give that.
Yes, these are only these three, my lord, because the first one they have given Gitanjali only. Yeah.
No, Miss, if I'm recording pages, I'll record together because it's easier
can-
for me then.
Yes.
In the second, 7624 is page 163, 166.
Yes.
Yeah, what are the pages in other cases?
7597, my lord, I have given
173
to
just a moment. 7597 is
173 to 176.
The number of the trains.
173 to 176.
Right.
And the ones we have got, because we have mentioned in our chart, given the page. Page 94 and 179.
In which writ petition?
7597.
7597, 173 to 176.
One is at 994,
Acha.
one is at 79, no?
170.
179.
Okay. Third one. 1171.
The charts are there in these two, I think, no? One second. These are consolidated charts, not all the
No, since I'm the page, you give me the page because it is easier for me.
My lord.
1171, what is the page of contract?
1171, my lord. The deed petition is not there,
It's not there. Okay.
but the subsequent
too
affidavits,
really-
my lord, they have some, my lord.
Just give that page.
The names of the
I'll
trains are
just-
there. I want to get. Not there. The trains notified
my
are
lord.
mentioned in these two pages.
Okay.
Page 38 to 43. 38 to 43.
Okay. And then we have your chart, two charts.
Yes, two charts, which are
And
relevant because our two petitioners are getting from that.
Okay.
Deeply obliged.
Number one. One.
Yes.
May
Yes,
it be
yes.
apology minutes for the morning minutes.
Yes.
This petition challenges, my lord. A notice dated 16th of September 2022. And a rejection.
Mr.
was
Kayal is there?
Yes, my lord.
Dated-
He's on leave. He's just coming, my lord.
Okay, because he used to give us instructions on that hiring charges
I said to.
after some time. Let him
I
come.
can show from the show cause itself, my lords. I can show from the show cause itself.
I don't, there's a court order asking Mr. Kayal to give a,
It's a part of the show cause itself, my lords.
it's okay. Once the
My
court, there's a court order, we'll
Lordship,
go by that.
lordship, please.
Just wait for some time.
Great, great, great obliged.
May I appeal? Yes, my lord.
Just. Yes.
Yes, my lord. I have got a telephone instruction, my lord. This land is situated in tribal area, my lord, tribal belt, my lord. Otherwise also he is not eligible to entitled to get settlement, my lord.
I know, my
And the
lord,
judge has
noticed
this is
them.
tribal
I
area.
will-
There's no doubt about it, because the 1950, that is my paragraph 2, my lord. We have been shifted there after that earthquake of 1950.
Mr.
All
I'm
of
just
us.
issuing a
We were
notice
there since
at this stage.
1950. We have made a statement in paragraph 2 itself also.
No, because if it's a tribal
Let
belt.
them, let them, let them
If-
consider,
if
let
it
them
is-
reject
if it is-
that.
If it is declared as a tribal belt, then
He
we
has
can't do
been
anything.
already, my
No,
lord,
no, I
privately,
know.
my lord, inform my lord,
Let
we are
them
taking
give
a
the
decision,
finding,
my lord,
that
within.
we are, all of us, even my learned friend is from that place. Their father, they are born and brought up there. He's a 73 years old man. All of them.
No, that may be
because-
there, but once it's a tribal belt, the
Yes.
new settlement may
No, no,
not be
no,
possible.
not new settlement, my lord, there is a provision law, see. In this chapter 10 itself, that is, in a reasonable time, if you are there, then you are entitled. So see 163, 2B. Chapter 10, Lordship. That is why this reasonable time thing is there, Lordship. (163) Lordship. Disposal of land for the purpose of cultivation and etc. Then, 2, in adopting and directing such policy or procedure the state government shall take into consideration first the bona fide need of the persons belonging to classes notified under the so and so, section 160, who are permanently residing in such area from before in the constitution of section 161. So loss, you have to see the notification. When the notification under section 161. Second is that the bona fide need of the persons belonging to such classes who are temporarily residing in such area from before the constitution, but who are settlement holder of land within that area on the date of its constitution and who are likely to undertake to become the permanent resident therein within a reasonable time. So we are there since 1950. That is my statement made in my petition lawsuit on oath. Let the deputy commissioner give an hearing, will satisfy him that we are there. Because let's say after the earthquake, let's say no, the Brahmaputra has come this side. So we are going to that side. We are from Majuli, in fact. My client is from Majuli. But after the earthquake, the Brahmaputra come to this side, so we went to the other side.
It's okay, I have my own reservations because of the fact that 163 is for disposal of, for the purpose of cultivation.
It's cultivation, I know, but there the reasonable time is there and the lordship, there are two
Oh, that's
judgment
okay.
lordship. That the reasonable time, if a person is there, then they can sell or purchase the land even in the tribal area. Let them pass a speaking order lordship that I am in tribal area, I am not entitled lordship. Let them pass that order, deputy commissioner. Let them pass that order. That is that speaking order lordship.
He has annexed my lord, it is of 2002, my lord.
It's okay, but you dispose it off.
No,
Yes,
no,
my
that
lord,
is
they-
say,
they-
If it is a requirement to dispose it off,
from someone.
They have already informed that they are taking a decision within a short period of time, my lord.
we'll give a 3 weeks notice. We'll give a 3 weeks notice. In that time, you do it.
Yes.
Even
Let
my
them
lord,
decide, let them
within
pass a
2 weeks, my
speaking
lord, they
order.
can take a decision, my lord.
We'll come and challenge that.
Uh,
Give us some opportunity lordship.
But Mr. S. Sharma, the senior counsel, assisted by Mr. T.K. Bhuyan, and counsel for the petitioner. And Mr. N. Chetial, and a government advocate appearing for. You for all the respondents?
Yes, my lord, lordship may dispose of, my lord, asking them to take a decision within 2 weeks, my lord.
Okay. You'll be for respondent numbers
I'm for respondent number 3 and 4, my lord.
for 3 and 4, Ms. G. Hazarikal and government advocate appearing for respondent number 1 and 2. Right?
One.
It's not about one lordship.
So who will be for 2? Revenue secretary, revenue and disaster management, who will be there?
Lordship.
You will be there for 2 also. Next one. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has paid for quashing of the eviction notice dated 23/5/2023 and to direct the respondent authorities not to evict the petitioners the petitioner and to Mr. Sharma, payer number C, what can I do?
Lordship.
Should not be issued.
Still not known. Sorry. I have not
To
seen that.
direct the respondents to finalize the settlement process of the land, which is the subject matter of notice dated 23/5/2023. Next paragraph. The case of the petitioner is that in the year 2002, the petitioner has purchased possessory right over a plot of land measuring 1 katha 1 dacha, together with houses standing thereon from its previous possessor. The petitioner claims that he is in uninterrupted possession of the said land. And has been paying the requisite land revenue, public fine, as well as the electricity charges, and is operating a grocery shop by constructing a some type of house thereon. Full stop. The petitioner claims that on (30/11/2021), he has submitted an application for settlement of the land in his favor, which was received as application number 962 dated 30/11/2021 in the office of the Deputy Commissioner. Which place?
Lakhimpur, my lord.
Lakhimpur. So it is submitted that as the application for settlement has not yet been disposed of, petitioner could not have been evicted without taking a decision thereon. Next paragraph. At this stage, the London Government Advocate has submitted that he has received instructions to the effect that the application of the petitioner is under active consideration, and a review would be made to dispose it of within a period of 2 weeks.
Yes.
Next paragraph. In view of the submissions made by the London Government Advocate, the court is of the considered opinion that instead of keeping this matter pending, the matter can be disposed of at the motion stage by directing the Deputy Commissioner Lakhimpur, North Lakhimpur, within bracket respond number 3, to first dispose of the petitioner's settlement application number 962 dated 30/11/2021, preferably within a period of 2 weeks from the date of receipt of certified copy of the order.
Yes.
Most of it is also provided that till a final decision is taken on the said petition number 962 dated 30/11/2021 within bracket annexure 6, the effect of the eviction notice under serial number number is 37, serial number so dated 23/5/2023 shall be kept in abeyance. Next, the petitioner shall produce a certified copy of this order before the Deputy Commissioner Lakhimpur, North Lakhimpur, within bracket respond number 3, to bring this order to the notice of the said authority.
Reasonable opportunity of hearing be given, lawsuit. There are poor people, at least they can satisfy showing the document lawsuit.
Well, I don't think there's a hearing required.
It can be hearing, they can give an hearing lawsuit, because lawsuit, they will decide this. all these.
Because
necessary.
otherwise, no, because what happens is that we now, by these orders, we open up a new vista.
Lordship, then I.
Because no, you see, no, not that.
I get it.
You
I
know,
get it.
there are many
Lordship,
other
Lordship,
elements who may take the advantage of
Lordship,
these orders.
I do not want to do that.
So,
There are lots of Kabula
No,
applications.
no, I do not want to do that.
no, it's okay. But you can just request the deputy commissioner if he wants to, Mr.
Necessary.
Sharma, if he
Because
can.
these people,
accommodate.
poor people, they have come after the 1950 earthquake to this side of the Brahmaputra.
Okay.
That's the whole problem, Lordship.
We will not make it a part of order, but you can still request if an audience can be given.
I'm good.
You can also make a request
Lordship, Lordship will file an application.
Because we have difficulties once we pass
Lordship,
an order.
I don't know.
Item number 1.
Yes. You got the
In this
information?
case, so-called notice was issued to the petitioner on the ground that he has tried to evade some tax, did not pay the tax. And Lordship, in my first submission is that the writ petition is premature because nothing has been decided and he will be given opportunity to file his reply and there is an alternative remedy available to him also. When there is a.
No, you see, when
filing
they can demonstrate that the hiring charges is only 1,99,000.
Lordship, that is not, Lordship may come to page 108.
No, I have not yet heard the learned counsel for the petitioner.
No.
I'm asking you because in the last order,
Yes,
here
Lordship.
it says Mr. Kyal shall obtain instructions with the GST on hiring charges and remaining claim is for an amount of so and so.
That is not correct. Lordship may come to page 108.
108.
Lordship.
Because I have not yet heard
Yes, Lordship.
counsel for the petitioner.
Paragraph 11. Total amount of GST involved. Lordship, last 2 columns, matter relating to royalty. The amount is 4,50,718 and 13,62,358. And rest of the amount, total amount involved is 1,96,59,289. So the royalty amount is very less. And one matter is pending before the Honorable Supreme Court. But see, even then, we can continue with the investigation and come to a conclusion. If there is any demand that can be, Lordship, we will not take any.
I'll hear
Lordship.
the counsel for the petitioner first. Yes.
My apology, my lords. I was not able to hear what my language friend said. My lords.
Yes.
May I just submit, my lords? Now, this petition challenges the notice, my lords. Your lordships may kindly see the notice was issued to me. The investigation was started on the ground that you have paid certain royalty to the state. This is for mining. You are given a mining right. You have paid certain royalty to the state on which you have not paid GST. That's the sole issue, my lords. That was the sole issue, my lords. Your lordships can kindly come to the show cause notice, my lords. This investigation, my lord, starts under the provisions of section 67 of the CGST Act, my lords. 67 is a very specific provision, my lords, which is based on intelligence, on reasons to believe that there is a likely evasion of tax, and therefore investigation is started not by the jurisdictional officer, my lords. Not by the jurisdictional officer. I am a registered assessee, my lords. I am a registered assessee. I have a jurisdictional commissioner. This investigation is started by the officers of the DGGI, my lords. On the ground,
CGST.
lords, I had handed over a compilation.
CGST. Customs license.
May I just hand over, my lords? I prepared a compilation which will assist your lordships. My lord.
Central Goods and Services, CGST. Central Goods and Services. Yes.
Lordships. I'll just briefly narrate, then I'll take your lordships to know what principally is the challenge, my lords, which according to me, they could have easily redressed. And it would not have invited me to invite a judgment from your lordships, my lord, very narrow compass, my lords. The investigation was initiated under the provisions of section 67, saying that I have reason to believe And consequently, under section 70, summon was issued to me. Summons were issued, my lord. My lord, this is not a regular proceeding, my lord. That's what I wanted to demonstrate before your lordship, my lord. On the ground, you have got certain licenses from the state. State is allowing you certain mining operations on which you are supposed to pay royalty to the state. And that royalty, you are liable to pay GST on a reverse charge basis. My lords, I'll tell you lots what a reverse charge basis is, my lords. Under the scheme of the Act, under the scheme of the GST Act, every supply is taxable. Subject to exclusions and exemptions, my lord, supply is taxable. Supply is from one person to another in the course of furtherance of business and for a consideration. That's section 7, my lords. I'll show your lordship these provisions. Under the charging section, that is section 9. There is section 9(4) which says that instead of the supplier, the receiver will pay the tax. It's more like a purchase tax, my lords. When I purchase goods and services, so there is an there is a notification which says when you purchase goods and services from the government, receiver will pay tax. Government will not pay tax. Their case against me was precisely this, that the government has provided a service to you. What is that service? Allowing you to mine. They are the owner of the mine, allowing you to mine sand, etc., for which you are paying a royalty to them. On this royalty, you are liable to pay GST. I presented before them, lords, and my statement was recorded. In that statement, I told them, sir, I have already paid tax. So the royalty is 100. I have paid 100 plus 18 on that to the state government. I have already paid it to them. Therefore, there cannot be any double taxation. I have already paid it to them. State ought to have paid it to you. They have collected from me. They ought to have paid it to you. That was ignored, my lords. That ended there. During the course of this inquiry, they asked me further certain documents. Show me this, show me this. They conducted what is called a regular audit. That provision is contained under section 65, my lords, which they are not empowered to do because they have not followed the requirement of law under 65. And these other demands, my lords, which my learned friend was pointing out, some machinery hire charges or some works contract tax or mismatch, reconciliations, pure reconciliations, my lords. This is nothing but a job of an auditor under 65, not a job of the investigator under 67 read with 70. They have expanded the scope of the investigation, my lords, and conducted a function of audit without following what 65 says. My grievance is that, my lords. I have no grievance that you should not have done that, my lord. You can do that. Even today you can do it. I have no difficulty. I am subject to audit. I will comply with that. My grievance before your lordship with folded hands is, my lord, without following the procedure prescribed under 65, this notice has been issued to me. Number 1, my lords. Be that as it may, they issued this notice to me. I file a reply. I file a reply saying that please provide certain documents to me. Please provide certain clarifications to me. Lordships may kindly have that letter, my lords. This is the main root cause, my lord, which I am before your lordships, my lord. Lordships may kindly have that letter, my lords. I make a detailed submission, my lords. It starts at running page 142 of the compilation, my lords, of the paper book. Page 141, my lords. Has my lord got annexed? Just see page 141.
Yes.
Lordships. Application under section 165(5) of the CRPC to the commissioner designated in the place of the magistrate in terms of section 67(10) applicable to all investigations before commencement of any adjudication under section 74. There, my lords, kindly have page 142, my lords, where I provide this submission, my lords, that under the law, I am entitled to seek these clarifications. 1, please give me reasons to believe that you had under 67. Please give me reasons to believe that you had under section 70. Please provide me with cross-examination. It's a detailed submission, my lords. I can take your lordships through that. Several my lords, copies of the reports I've sought. Kindly see para 12. I've sought copies of the reports. That you please provide me copies of the reports. Please tell me why pre-show cause was not issued. My lords, under the scheme of the act, before issuance of show cause notice to every assessee, they ought to give a pre-show cause. Pre-show cause is, my lord, saying that we don't want unnecessary disputes and litigations. If a party accepts and pays, we will close it. We will not issue any show cause because our intention is not to litigate. Therefore, a scheme, lordship, this earlier under the service tax regime, under the excise regime, under the erstwhile regime, this same scheme was operated through board circulars. The board had issued circulars saying that don't issue show cause, give a first pre-show cause. It's like a pre-show cause saying that why I should not issue show cause notice to you. If the party agrees, party pays, close it. That also has not been done, my lords. Though, my lords, I must point out as an officer of this court, my lords, the section prior to 2020 provided, lordship, there has been amendment to the section. Your lordships will have to deal with that, lordship. That's my part of my submission. There is a judgment of the Honorable Delhi High Court. There is a judgment of the Honorable Chhattisgarh High Court. The judgment of the Honorable are all saying pre-show cause is mandatory. Pre-show cause is mandatory. If there is no pre-show cause, show cause goes. You first issue pre-show cause and then proceed. Lordship. But may I just point out, my lord, as an officer of this court, there has been amendment to the law, where under the rules, my lords, they have rephrased the word shall by may. Lordships. Therefore, they may have discretion whether to issue pre-show cause or no. That's a question that falls for my lord's consideration. My lords, I'll have to address your lordships on that. I must point out that, my lords. I'll show the section also in just a minute, my lords. This is a detailed submission that I make, my lords. And kindly look at the reply that they give me. They give me a reply. Sorry, sir, we have already issued show cause notice. This is their reply. Kindly have page 140, my lords. Kindly have running page 140. 140, my lords. This is in reply to this detailed representation that I make, my lord, which runs into more than 25 pages. This is the one-line reply that they give me. Has my lord got page 140?
Yes.
Lordship, please. Para 2 onwards, my lords. In this regard, it is to inform that the investigation initiated by the matter by DGGI, Guwahati Zonal Unit, is concluded, and a show cause is issued under section 74 read with rule 42 has been issued by the competent authority. The issues raised in the said show cause have been sent before the Assistant Commissioner for adjudication. Since the matter is sub judice before the Departmental Judicial Forum, you are therefore requested to kindly submit your reply before adjudicating authority during adjudication proceedings in the matter.
Yes.
Now, my respectful submission, my lords, for my lord's kind consideration is this. What is, I have not asked you to adjudicate. This is pre-adjudication only. I am seeking certain documents on the basis of which will enable me to give a reply. My limited prayer today, my lords, is let them comply with my requirements at page 141, my lords. I am willing to file a reply to the show cause notice, then they can adjudicate the show cause notice. Otherwise, my lords, I can demonstrate before your lordships, they do not have jurisdiction to adjudicate and issue the show cause notice. I can demonstrate before your lordship subject to what my learned friend has to say. Apart from that, my lords, on the last occasion I pointed out before lordships, my lord, even this issue, whether loyalty is a tax, my lords, is pending before a 9-judge bench of the Supreme Court, my lords, and the Supreme Court has stayed these matters, saying that don't adjudicate. There is a stay. There is several. I filed a paper book also on the last occasion. All the high courts of the country are unequivocally taking this view, where all these demands or these notices are stayed, saying that this issue is pending before the Supreme Court. Your lordships have that compilation, my lords?
Yes.
Lordships may kindly have running page 11, the very first, my lords. This is a stay by the Honorable, my lord, the Chief Justice, Honorable the Chief Justice, my lords. Kindly have para 3, my lords. Until further orders, payment of GST for grant of mining lease, royalty by the petitioner shall remain stayed. And my lord, then there is a Gujarat High Court judgment on the same issue, my lords, is a detailed order. Then, my lords, there is a Jharkhand High Court judgment, Andhra Pradesh High Court judgment, Allahabad High Court judgment, my lords, all on the same issue. That since the matter is pending before the 9-judge bench of the Supreme Court, my lords, there cannot be any action on this, my lords.
This order can't be read as a judgment in rem.
Lordships.
It also always taxing. Primarily be order in personam.
Lordship, please. Certainly, my lord. My only submission is that this issue is at large before the apex court, my lords. Therefore, let the adjudicate. My only prayer is let him not decide, my lord. That's my limited submission. There is no demand against me today, my lords. Lordship, what they can, your lordships can invite them to file a reply. I have no difficulty. Let them not adjudicate till then. Let them file their reply, my lords, to the submissions that I am making, my lords. That's my limited prayer, my lords.
Okay. Yes.
Subject to what my learned friend has to say, my lords. I am obliged, my lords.
But see, my first submission is that the writ petition is premature because only the so cause notice has been issued. And this issue has already been decided by Supreme Court. Lordship. The paragraph 19.
But Supreme Court never said that you don't give a copy of the documents which is wanting.
Lordship may come to page 131. With so cause notice, all the documents has been supplied to them. Page 131 is a part of so cause notice. Lordship has seen their application seeking document. They're only aim it to derail the investigation, Lordship.
No, whatever if you want a
We have-
document, you give
No,
it
we
to
have
him.
already supplied, Lordship. Please to see page 131. List of documents relied upon by the so cause notice issued under so and so. That is supplied to them.
Are these the only things he is wanting?
We are relying on these documents only.
No. You
Lordship,
may
they
rely.
will- they will ask for some documents which are not in existence even, Lordship.
No, then you see, you can
We have-
always give a reply that it
No, we have
doesn't
given
exist.
reply, Lordship. Page 140.
You don't say that.
No, Lordship, page
Yeah.
1. And page 131 is the documents which were relied in the so cause notice that's been supplied to them. And they Lordship, interestingly, these documents were supplied by them to the department during the so cause not initial stage. Lordship. The entire GST is a self-assessment, Lordship.
You see, the authorities will only have to say that this document, document X you are wanting, it is your document, you have supplied it to us.
No, Lordship, please to appreciate. Page 131 is the part of so cause notice. Lordship, please to see.
Which one?
Page 131.
I am there at 131.
Yes, Lordship. First, copies of summons and authorization letter. They're asking for copies of statement of Sri Santilal Jain.
No, just a moment.
Representative of the
Let me come
petitioner.
to.
Then 3
Yes,
copies of
please show us your that requirement. What are the documents you are wanting?
Lordships may kindly have page 142, my lords. It starts
142.
from there, my lords. The first.
Just identify the documents.
Yes, my lord. First is reason to believe. Kindly see para 3 of the show cause notice that information was gathered that we have reason to believe that you have evaded GST on royalty, my lords.
Okay.
Section 67 says that the officer should, Lordship may kindly have section 67. Everything is in the act, my lords. I'm not asking anything beyond the act. That is why they are giving an evasive reply saying that I have given a show cause notice. Kindly have page 6, kindly have, my lords, this compilation, my lords. This one, my lord, which was the royalty compilation, then they handed over on the last occasion. It's from page number 1 to 29, my lords.
Huh.
Yes, my lord. Kindly have page number 6 in that, my lords.
16.
Running page 6.
6.
Running page 6, kindly have section 67, my lords.
Yes.
These are serious provisions, my lords. Where the proper officer, not below the rank of the joint commissioner, has reason to believe that I have evaded tax. It is not a fishing inquiry, my lords. It is not an audit. I will show. There are provisions for everything. You conduct an investigation search under this. You have to give me reasons to believe. I'm asking for that. They are saying no. Very first, and kindly see 6710. It says that the provisions of the CRPC apply. Kindly have 6710, my lords. The provisions of the CRPC relating to search seizure so far as the applicable apply to search and seizure under this section, subject to the modification that 165(5) of the code shall have the effect of the word magistrate substituted with the commissioner. I've made an application under 165(5) to the commissioner, give me these documents. On what basis have you done this?
165 CRPC doesn't say so.
Yes, Lord.
165 is the protection in a search and seizure.
Lord, should I
You-
have that?
Sixty-five is not to give them, they will not give you anything, the police. It's merely that once you are searched, it will be officer will give you an opportunity for himself being searched. Then he will search your premises.
Lordships,
Then what you call, he'll have witnesses
lordships.
and what you call the section 100 would be complied. That is the only thing. 165 does not say give a document.
Lordship, that is 165 read with 167(10) and 67(1). Kindly have 67(1), my lord, the proper officer. That also I ask, where is the copy of the authorization from the proper officer? See serial number 2, lordships.
So that authorization you won't have, because you see, it's a general circular which says that officer of the department of a particular rank and onwards
Lordship.
will be a proper officer.
No. I'm not on that, my lords. With great respect. There has to be a specific authorization by an officer not less than the rank of the Joint Commissioner to conduct this inquiry, to conduct this investigation.
For every case, they will have to take a.
Yes, your lordship. Yes. My respectful submission answer is yes. Because this is 67. Lordship may kindly have 65 now. 65, they don't need anything. If that they have followed, Lordship may kindly have page 4. This is my precise grievance that you came under 67, 70 and then started 65. How can you do that? Kindly see 65, my lords.
Yes.
The commissioner or any officer authorized by way of a general or a specific order may undertake audit of any registered person for such period at such frequency and in such manner as may be prescribed. The officer referred to under 1 may conduct audit at the place of business of the registered person on their office. This is what exactly they have done in my case. In not following this procedure, kindly have 3, my lords. The registered person shall be informed by way of a notice not less than 15 working prior days to conduct an audit in such manner. Nothing. The audit under 1 shall be completed within a period of 3 months from the date of the audit. Where the commissioner is satisfied that this requires more time, he can extend up to a period of 6 months. During the course of the audit, the authorized officer may require the registered person to afford him necessary facility to verify the books of accounts or other documents as he may require, to furnish such information as he may require and render such assistance for timely completion of audit. On conclusion of the audit, the proper officer shall be.
CGST. You have the book on CGST?
Not serious.
Just pass it on because it's easier than to read this.
That's it.
Yes, so audit is defined in subsection 2, subsection 13. Audit.
Lordships. There is a power for special audit also, my lords.
Yes.
Yes.
Special order is
65 says that after
Ah.
conclusion of the audit, they have to give me an audit report based on their findings, that whether according to them there is a liability or no, giving me an opportunity to give a reply to it, my lords, and then giving me an opportunity to pay the tax. If I
Then-
contest,
Then just
Then-
a moment. Then I think I'm missing something. The question of audit I did not find in your show cause notice.
in the
Was audit done?
no, my lord,
not
that's
done.
my submission.
Oh, okay, please repeat again.
My
I didn't
apologies,
get
my
it.
sincere apologies, my apologies, my lords, my sincere apologies, my lord. My precise grievance before a lordship with folded hands is this, they invoke the powers under 67 to do 65 without following the process under 65. They came to my office saying that, give me this document, okay, machinery hire charges, pay tax. Give me this document, okay, pay tax. Give me this document, there is a mismatch in your reconciliation. They have conducted a full-fledged audit. And that is why I asked them.
You are saying that they come in guise of section 67
Lordships.
and they conduct 65.
Lordships. That's my precise submission. That's my precise submission, my lords. And this audit has to be conducted by my local jurisdictional officer, who is authorized by my commissioner. And they are free to conduct it even today also, my lords. He can conduct it at any such point of time, any frequency, as may be notified by the commissioner, my lords. He has to give me 15 days prior notice also before coming. Then he has to give me an audit report. Then he has to give me a chance to give a reply to it. Then he has to give me a chance to whether to pay tax or contest. And then, my lords, kindly see last subsection 7. Then the proper officer may initiate proceedings under 73 or 74. That is a show cause notice. Here straight they have issued 74 show cause notice to me, my lords. 67 doesn't refer to 73, 74, my lords. These are two distinct, independent, classifiable silos of powers, my lords. That's my respectful submission, my lord, that they have overstepped jurisdiction. My submission is not that DGJ officer is not a proper officer. No, I have never said that, my lords. The DGJ officer is not an excise officer or a DGJ officer is not a GST officer. No, I am not making that submission. They will show the notification. I'm not making that submission. I'm only saying that a proper officer also has jurisdiction under the statute. They cannot overstep it. In the guise of invoking 67, do not do 65. If you do 65, please do, fair enough. But please follow the process. Please don't put me to this. This caused me to give them this representation saying that please give me these details. And their response is not, that I don't have these documents. 1. 2, their response is not, I cannot give you these documents. 3, no, your application is misplaced. No, that's not their response. Their reply is, I'm very sorry, I've already issued show cause notice. That cannot be, my lords. That is my respectful submission is that a reply is required from their side, my lords, on this.
Yes.
As pointed out, let's see page 31, 131. The documents which were relied in the so-called notice were supplied to them, lords. First document is the copies of summon and authorization letter, which are they asking for. Then there are 11 documents were supplied to them. Now, lordship, their submission is that we have not invoked the provision of section 65 of the audit. That is not required. They want to derail the investigation. Lordship, we come to page 85. What was the reason for? Lordship, we come to page 86.
80?
Page 86, paragraph 3
86.
of the so-called notice. Information was gathered that
Just
Mr.
confirm.
Arjit Basumutari Kokrajar, being a work contractor, is paying royalty to the Forest Department Assam against extraction of stones and sands from the forest area, but has evaded GST by non-payment of appropriate taxes on the same. The GST on the amount paid by them to the Department of Forest is applicable under reverse charge mechanism, applicable to write CBSE notification entry number so and so. They said the said entry state the applicability of GST on the services supplied by the central government, state government under Union Territory or local authority to a business entity. Paragraph 4. On receipt of the information by the Director General of Goods and Service Tax, Intelligence Guwahati Unit, an investigation against so and so was initiated by way of writing letter seeking record relevant to the investigator. Subsequently, someone in term of section 70 of CGST Act 2070 were issued for submission of the documents and recording the statement concerning the instant investigation against Sri Manjit Basumutari. 5. During the course of investigation, summons dated 16 August 20th January 2020 were issued to Sri Manjit Basumutari under section 70 of the CGST Act. In response to the said summons, said Santilal Jain, on strength of authority letter dated 14th August 2019, issued by Sri Manjit Basumutari, proprietor of so and so, appeared before the officer of DGGIG unit for submission of document and recording the statement in connection with the instant investigation. Sri Santilal Jain, authorized representative of Sri Marjit Basumatari, during his appearance on August 26, 2019 and 20th of January 2020, subscribed statement under Section 70 of the CGST Act. In this regard, one copy of summon and authority letter dated so and so RUD01 and statement of Sri Santilal, authorized representative of Marjit Basumatari, are in RD2. Sri Santilal Jain, in his statement stated following facts concerning the then Lordship one, Paschim Madari holding GST number so and so is a engaged contractor of the road bridge building. It is proprietorship business so and so. Then two, royalty amount are paid by Marjit Basumatari against the procurement of forest produce, namely sand, gravel, stone, boulders from the allotted by the forest department. See, that the procured sand, gravels and boulders from the allotted sites are used for construction of the road bridge. Then they are not known the fact that the GST on royalty is applicable under RCN, not to be decided by them. At the same time, they rent out their assets like roller, trucks, genset, etc. to other parties for commercial use without entering into and written contract agreement. They do not raise any bill or invoices. 6, they have not paid GST on the receipt of the payment which are recorded in their books of machinery hire charges. That they are paying GST correctly and contract and submission. So this was their submission. The submission of these documents were submitted, and thereafter all the scrutiny was there. Then let's see, may come to page 108. After scrutinizing all the documents, this amount to be found to be involved in GST lordship. And their main contention is that main amount is regarding royalty lordship. That is not correct, lordship. Please to see that paragraph 11 of page 108. Royalties with respect to only 13 lakhs, about 17 lakhs only, lordship, out of total amount of 1 crore 96 lakhs 1 crore 96 lakh 59,289. Then lordship may come to page 124, paragraph 10.16.
Page
124, paragraph 10.16.
yes.
Where any person, I am reading lordship, paragraph 10.16, section 155, burden of proof. Where any person claim that he is eligible for input tax credit under this act, the burden of providing such claims shall lie on such person. 11. Suppression of the fact by Marjit Basumatari, as brought out in the aforesaid paragraph. It appears that Marjit Basumatari has been engaged in supply of taxable service classified under SSC 9954, 9973, 9972, and 9966. However, before initiation of the instant investigation, Marjit Basumatari has failed to assess their correct tax liability despite supply of different taxable service under different SSC of GST tariff, and thus they had failed to pay their correct GST due to the period from July 2017 to March 2019. Next, that Marjit Basumatari's suppression of the fact set also miscalculated their input tax credit availed and utilized by them through GST R3B for the period from July 2017 to March 2019, and had utilized excess of the input tax credit which was never available to them through GST R2A. Further, Marjit Basumatari at no point of time before initiation of the investigation by DGGI had declared their taxability or materials facts to department. They have also failed to assess their correct GST liability on assignment of right to use natural resources applicable to them under Section 9 of CGST Act under the SCM. So these are the facts revealed during the end Sokos notice was issued. And Lordship, they have been asked to give their reply. And all the documents which I have pointed out, page 120, 131, have been supplied to them. And these documents were supplied by them. And regarding authority letter, that is also supplied to them. Regarding Lordship, reason to believe, we are not liable to disclose to them. If your Lordship asks, we can produce the file before your Lordship. And in this regard, Lordship, I want to rely on judgment of Honorable Supreme Court, although this was in case of income tax. Lordship, this is relevant in this case also. Lordship, citation is 2022. 0 Supreme SC page 613.
What is the page number?
Page number 613. The title of the case is Principal Director of Income Tax versus Laljibhai Kanjibhai Mandalia. Lordship, I am relying on the direction issued by the Honorable Supreme Court in case of search and seizure. Paragraph 33, Lordship.
Will this ratio apply in GST also?
In my humble submission, Lordship, it will, because the direction issued by the Honorable Supreme Court is applicable in case of all search and seizure laws. Paragraph 33, Lordship.
Just a minute.
No, AIR 2022 SC 333304. Paragraph 33 laws.
Yes.
Paragraph 33. We would like to restate and elaborate the principle in exercising jurisdiction in the matter of search and seizure under section 132 of the Act as follows. It is under the Income Tax Act. 1. The formation of opinion and the reasons to believe recorded is not a judicial or quasi-judicial function, but administrative in character. 2. The information must be in possession of the authorized officials on the basis of materials, and that the formation of opinion must be honest and bona fide. It cannot be merely pretense. Consideration of any extraneous or irrelevant material would vitiate the belief or satisfaction. 3. The authorities must have information in its possession on the basis of which a reasonable belief can be founded that the person concerned has omitted or failed to produce books of accounts or other documents for production which summons or notice has been issued, or such person will not produce such books of accounts or other documents even if summon or notice is issued to him, or 4. Such person is in possession of any money, bullion, jewelry or other valuable articles which pretends either wholly or partly income or property which has not been or would have not been disclosed. 5. Such persons may have to be placed before the High Court in the event of a challenge to the formation of belief to the competent authority, in which event the court would be entitled to examine the reason for the formation of the belief, though not the sufficiency or adequacy thereof. In other words, the court will examine whether the reasons recorded are acquitted by malafide or on a mere pretense, and that no extraneous or irrelevant material has been considered. 6. Such reason forming part of the satisfaction not are to satisfy the judicial consciousness or of the court, and any part of such satisfaction is not to be made part of the order. 7. The question as to whether such reasons are adequate or not is not a matter for the court to review in a writ petition. The sufficiency of ground which induce the competent authority to act is not a judiciable issue. 8. The relevance of the reasons for the formation of the belief is to be tested by the judicial restraint as in administrative action, as the court does not sit as in court of appeal, but merely reviews the matter in which decision are made, the court shall not examine sufficiency of advocacy thereof. Then 9, in terms of the explanation inserted in Finance Act 2017 with retrospective effect from 1/4/1962, such reason to believe as recorded by income tax authority are not required to be disclosed to any persons or any other authority or the tribunal appellate authority. In view of the same, the writ petition was dismissed. So although it was in the income tax lordship, but the ratio will applicable in this case also. If lordship directors will place the record lordship or perusal of lordship. And moreover, lordship, this is a mere so cause notice, all the documents were provided. Alternative remedy is there before them. After their reply, there will be adjudication order, there will be subject to appeal, and thereafter before this honorable court. And the judgment placed by me, lordship, in the case of Union of India versus Coastal Container. This is with respect to GST also. Lordship, I am relying paragraph 19 of that judgment clause. Paragraph 19, lordship. Will not further your lordship with other paragraph. Here, 2019, 2019, volume 20, SCC. Page 446.
You subscribe to GST.
Lordships,
GST citation will be 2019
lordships,
73 GST 211
211.
coastal container.
Yes, sir.
Lordships,
This is reported in SCC also.
Okay, yes.
2019, volume 20, SCC page 446.
this is all. Please leave it on you.
I'll supply copy to my learned friend.
SCC is also there.
Lordships,
2019-20 SCC 446.
I'll get a copy. I'll get it.
Lordship, I'm relying on paragraph 19.
Yes.
On the other hand, we find force in the contention of
SCC paragraphs may not match.
May not match. Yes,
Okay.
lordships. These citations may not match.
On the other hand, we find force in the contention of the learned senior counsel, Sri Radhakrishnan, appearing for the appellant that the High Court has committed error in entertaining the writ petition under Article 226 of the Constitution of India at the stage of so-called notices. Though there is no bar as such for entertaining writ petition at the stage of so-called notice, but it is settled by number of decision of this court where writ petitions can be entertained at the so-called notice stage. Neither it is a case of lack of jurisdiction nor any violation of principle of natural justice is alleged so as to entertain the writ petition at the stage of notice. High Court ought not to have entertained the writ petition, more so when against the said final order appeal lies to this court. The judgment of this court in the case of the Union of India versus Guwahati Carbon Limited Supra relied on by the learned senior counsel for the appellant also supports their case. In the aforesaid judgment arising out of Central Excise Act 1944, this court held that the excise law is a complete code in order to seek redress in excise matter, and held that the entertaining writ petition is not proper where alternative remedy under the statute is available. When there is a serious dispute with regard to classification of service, the respondent ought to have responded to the so-called notice by placing materials in support of their stand. But at the same time, there is no reason to approach the High Court questioning the very so-called notices. Further, as held by the High Court, it can be said that even from the contents of the so-called notices, there are no factual dispute. Further, the judgment of this court in case of Maladi Drugs versus Pharma and Sonso relied by the learned senior counsel for the appellants also support their case where the case has upheld the judgment of the High Court which refused to interfere to so-called notices. This is the law laid down by the Honorable Supreme Court in case of notices. Here, Lordship, the notice was issued by the proper officer. There is no violation of principle of natural justice. All the documents relied in the so-called notes were supplied to them, Lordship. And there will be adjudication, that they can file appeal before the department authority, and even remedy lies to them before this novel court also. Although there is a provision for appellate tribunal, but that has not been constituted yet. So appeal lies, writ petition lies before this novel court. Yeah, 2022 SC 330. Lordship, another issue. My learned friend cited one judgment of Honorable Supreme Court with regard to royalty. Lordship, I want to read that entire paragraph, Lordship, for clarification. That is page 17 of compilation submitted by my learned friend, Lordship. That is in the case of Guzmin Industry versus Union of India. Paragraph, page 17, paragraph 9.
Yes.
In the light of the above discussion, issue rule, the learned standing council waived service of notice of rule on behalf of the respective respondents. By way of interim relief, it is ordered that until further order, payment of service tax for grant of mining lease royalty by the member of the petitioner association shall remain state, subject to each of the members of the petitioner association filing an undertaking before this court and endorsing a copy thereof, the respective department or departments undertaking that in case they ultimately do not succeed in the petitioner, they would discharge their obligations for payment of service tax on the royalty. In case of the respondent succeeded in civil appeal before the Supreme Court, this court shall hear the learned counsel for the respective parties on other issues which have been raised in the present petition for purpose of continuation of the interim relief, including contention that the other rights being nature of profit and pantry. Profit and Lordship has seen, as pointed out in paragraph 11, page 108. The total amount of GST involved. Lordship only last two columns with respect to royalty, but these are different head throws. Even if Lordship, even if the judgment of the Supreme Court is applicable in this case, Lordship, that doesn't bar the department from executing. Yes, Lordship. We may be restrained from realizing them, but we can determine all these amounts, Lordship. All these tax involved in this case, Lordship. Even if, Lordship, this judgment is applicable in case of death. So if I have a further submission with regard to royalty amount. Lordship may recollect that on other day, with respect to IBC, section 14 parts, then when a moratorium is issued, there cannot be any adjudication. But your Lordship held that on the basis of Supreme Court judgment, that adjudication be there, but we cannot realize the amount. And we have to submit to our claim to the IB officer, Lordship. Here in this case, Lordship, since the matter is pending before the Supreme Court with respect to the royalty, Lordship, it doesn't bar the department from proceeding further to determine the tax liability laws, if any laws.
You are Mr. Raichandani?
Lordship,
Yes.
may I just submit? Let me make an endeavor, my lords, to answer what my learned friend raised this contention, my lords. In my respectful submission, according to me, my lords, my learned friend raised the fourfold contention. That's what I have understood from the submission of my learned friend, my lord, is this. One, this is only a show cause notice and therefore don't entertain the petition at this stage. Two, my learned friend was gracious enough to say that the Gujarat High Court has granted interim stay subject to you giving an undertaking to the court that if ultimately the Supreme Court holds against you, you will pay the tax. Three, my learned friend said that I am not supposed to give you reasons to believe because the judgment of the Supreme Court in income tax case says that I am not supposed to give you reasons to believe. Fourth, last, my lords, my learned friend said that this submission or the application or the representation which is being made by me is nothing but to derail the adjudication proceedings, my lords. This is the sum and substance of what my learned friend said, my lords, as I understood, my lords, and I make an endeavor to put it before my lords, is this. First, I am grateful to my learned friend, my lords. He read out from the show cause notice itself. I'll invite your lordships to the show cause notice, my lords. Kindly see where it started and where it has headed. My learned friend read out the first 4 paras, missed out the most crucial part, my lords, where they start conducting audit and straight away showed your lordships the conclusion. I want to demonstrate these 2 aspects from the show cause notice itself. And which are these 2 aspects? One, you start with 67, don't come to 65. You have not gone to 65, you have not gone to 66. That is the question of jurisdiction. That goes to the root of the matter, my lords. That goes to the root of the matter which my learned friend has not answered, my lords. I'll show from the show cause, my lords. Kindly have page 85, my lords.
Yes.
Lordship, kindly have page 85, para 2 onwards. They are saying that I am a registered taxpayer. They say I am a registered taxpayer, my lord. This investigation inquiries, my lords, happens in most of the cases where unregistered dealers are there. When you get a specific information that there is an evasion of tax, you go to their premises, conduct search, conduct seizure. Investigation, lordship, summons. Kindly see section 70 for a minute, my lords. Kindly have section 70, my lords. In the same compilation which I handed over, my lords, kindly have 70. Where a summon is required, your lordships are aware. Your lordships also issue notice, my lords. Where a summon is required, kindly have page 7, para page 7 of the compilation, section 70, my lords. Power to summon persons to give evidence The proper officer under this shall have power to summon any person whose attendance he considers necessary either to give evidence or to produce a document or anything in any inquiry in the same manner as provided in the case of a civil court under the provisions of the CPC. It's very, very specific, very important this. Every such inquiry referred to under subsection 1 shall be deemed to be a judicial proceeding within the meaning of section 193 and 228 of the IPC. This is very, very important powers, my lords. Cannot be applied routinely like this, my lords. That's my submission. What they do is this, my lords. Kindly come to para 2, my lords. They say you are a registered taxpayer. You are providing works contract services, engage in construction of roads and bridges for government bodies. That you are also engaged in extraction of sand, stone, gravel as a leaseholder, as a registered Maldra for so-and-so Assam, is paying royalty to the Department of Forest against services rendered by them to the Forest Department by way of assignment of right. These services are taxable on so-and-so. Then they say information was gathered that you are not paying GST on this royalty amount, for which we have started this investigation inquiry under 67, read with 70 summons. Lords, you may kindly see summons, which my learned friend read out. Para 4, my lords. On receipt of information, DGGI Guwahati, an investigation was initiated, summons were issued. And lords, what happened? I replied to the summons. I appeared. My submission of my learned friend that I am trying to derail is incorrect. At every stage, I will show I have appeared and I cooperated. I have cooperated right throughout. And this is not their answer for rejection also. This is a submission made across the bar, my lord, not even on oath, saying that you are trying to derail it. Their rejection is, I am very sorry, I have issued show cause notice. That cannot be done, my lords. Therefore, we are before your lordships, my lord, that has to go. And they have to be directed to produce these documents to me, which will enable me to give my reply. Today, my lords, my handicap is I cannot reply unless I know what are the reasons. Why did you invoke 67? Why did you invoke 70? Because that goes to the root of the matter. And if that goes, my lords, the entire proceedings go. That is the reason they are not wanting to give it to me, my lords. Then your lordships may kindly see, after my statement was recorded, kindly have para 6, my lords. Para 6. Here is where the river changes its course. Lordship, para 6. During the investigation, they submitted what, my lords? Copy of balance sheet. My entire balance sheet, my entire trial balance, all ledger accounts, they asked. Then lordship may kindly see para 7. Now where they are moving, where they are heading. Scrutiny of GSTR 3B and summary thereof. On the scrutiny of your GSTR 3B, lordship, this is pure scrutiny, nothing. No investigation, reading. There is a mismatch. Kindly see. Kindly see. There is a mismatch. There is a delay in filing your return. And on that basis, they are saying you are not eligible for credit on input tax credit, which is one of the major demands, my lords, that you are not eligible. This scrutiny goes under 65, my lords. This is precisely my reason for making a representation to them, saying that please provide these documents to me, please provide this clarification to me, which they don't. And the reason for rejection, my lords, is absolutely beyond the realm of jurisdiction also, my lords. That's my first submission, my lords. And kindly see, my lords, throughout my learned friend relied upon the documents, saying that I have given them documents, I have given them documents. Lords, you may kindly see that list. That list is exactly what I have given them. Kindly see page 131, my lords. Kindly have page 131 for a minute, my lords. My learned friend was my apology, my sincere apologies, my lords, my sincere apologies.
Yes, page,
page 131, my lords. My apology.
it's
My
okay,
learned,
131.
page 131. My learned friend kept arguing, my lords, that we have given them documents. Kindly see, this is what I have given you. During the course of investigation, these are all my submissions. Copies of my statements, copies of my letters, copies of my GSTR 3B, copies of my GSTR 2A. This all I have given you. My bills, my RA bills. I am seeking what you ought to give me. That's my submission. What you ought to give me under 67. 67 talks about reason to believe. My lord, there's a recent judgment of the Honorable the Chief Justice, my lords, under section 83 of the Finance Act, of the GST Act, very same act. Lordships 83 also uses the same word, reasons to believe. And his lordships, my lords, have, Honorable Lord the Chief Justice has interpreted that you ought to give these reasons to believe. In section 83 in Radhakishan Industries, my lords. 83 provides for, my lords, provisional attachment, where the commissioner should have reason to believe that if these demands are confirmed against you, will not be able to realize at a subsequent stage. Therefore, we will provisionally attach your properties or provisionally attach your bank accounts. Their same phrase, reason to believe. Same. Identical phrase interpreted by the Honorable Chief Justice, my lords, in Radhakishan Industries under the GST Act itself. Therefore, my lord, the judgment relied upon by my learned friend in the context of income tax will not apply. Secondly, my lords, my learned friend read out, my lord, there was an amendment to the Act. If your lordship sees the judgment, my lords, there was an amendment to the Act, to the Income Tax Act, where the Act provided that you don't need to give reasons to believe. That Act is at variance from our provision, my lord, that cannot be applied in our case. And that should be a reason, my lord, with great respect, for the authority to give me. Today, the reason given by the authority to me is, I am sorry, I've already issued a show cause notice. Whatever
The Radhakishan, the Kishan is spelled differently.
Lordship.
K-I-S-A-N.
Radha Kishan, K-I-S-H-A-N, my lords.
No, it's not Kishan.
Radhakishan Industries, my lords. Honorable Lord Justice Chandrachur, my lords, and Honorable
No,
Lord Justice
Kishan
M.R.
is,
Shah.
Kishan is,
I think I'm just getting a copy of that, my lords. I'll just circulate it to my lords.
K-I-S-A-N, I think.
Could be, my lords. Your lordships are right. Could be, my lords. My apology for that. But I distinctly remember, my lords, Radhakishan.
Himachal Pradesh. Lord.
From Himachal
It
Pradesh.
is from Himachal Pradesh.
From Himachal Pradesh High Court, my lords. There also this contention was raised of jurisdiction and alternate remedy, saying that the court, whether the court should have entertained, their lordship said the court should entertain. In the context of GST itself, my lords.
Okay.
That will have clear direct bearing in the present matter, my lords.
Radhakishan, K-R-I-S-H-A-N.
K-R-I-S-H-A-N, my lords.
So spelling is different.
Yes, Radhakishan Industries. This was from the Himachal Pradesh High Court, my lord,
Yes.
where there was a provisional attachment. The High Court usually dismissed, saying that you have an alternate remedy. Please don't come here. Then they made a representation under Rule 159(5) to the commissioner, which was rejected. Then again they approached the Honorable High Court. Again the High Court rejected, saying that there is a remedy, please go from here. Then they approached the Honorable Supreme Court, and Supreme Court says, no, High Court ought to have entertained. There is a discussion, my lords, on reasons to believe. It's a very beautifully written judgment, my lords, on this, analyzing this very phrase of reason to believe. And this, my lords, I can show from the entire act. This phrase has been used in many sections. It's a very important, my lords, according to me, it's the soul of this particular chapter in the act. If I show the scheme of the act to your lordships, my lord, section 65, 66, 67, 68, 69 is power to arrest. 69 is power to, that also, reason to believe. 70, reason to believe. The entire chapter, my lords. Because these are draconian provisions, my lords. Therefore, they cannot be invoked like an audit. That's my submission. And if you want to do audit, no difficulty, my lords. I bow down to them, I'm subject to audit. Then follow the procedure. That procedure has not been followed, my lords. No audit report has been given to me, no option has been given to me. Apart from the fact that a pre-show cause ought to have been issued to me. That also has not been issued.
That is not an audit. It may be a scrutiny or an examination, but it can't be audit.
Lordships.
It can't be read as an audit.
And my lords, if they want to conduct an audit, they have to follow 65.
That's okay, but they're not conducting that.
Lordships. This is scrutiny, my lords. Scrutiny is, my lords, in other words, reading of my balance sheet, my lord, my financials, which otherwise you would do an audit, which otherwise would have been done in an audit, my lords.
No. Audit is physical examination and then what the chartered accountants do.
Lordships.
Audit is physical verification, correctness of the accounts,
Yes,
correctness
my
of the
lord.
entries,
Yes, lordships.
what you call comparison with the stock available.
Lordships. This is what they have done. That's my submission, my lords. Kindly see what this is exactly what they have done. They may have termed it as investigation. They may have termed it as scrutiny. This is what they have actually done. This has been my grievance right from day one. That though you have titled as an investigation, this is not an investigation. You have conducted an audit. The DGJ officer conducted an audit in the garb of 67 read with 70. And therefore, the entire proceedings is beyond jurisdiction. That's my submission. That you have overstepped jurisdiction. And this is certainly an aspect which your lordships need to examine, my lords, in this petition. I come to my lordships, I put the worst case against me also, my lords. My learned friend pointed out. Lordship, I look at it like this, my lords, with my lord, for my lord's kind consideration.
You just give that paragraph later on about that reasons to believe.
Lordship, I'm getting a copy of that. I'll just circulate it to your lordship with the para numbers.
You can just tell me I have it. You don't have to give me a book. You just.
I'll just circulate the para numbers. I'll give the para numbers to your lordship. In fact, my lords, one beautiful judgment of the Gujarat High Court was confirmed by the Supreme Court, my lord, specifically on the reasons to believe. It's a very beautiful passage. Entire history has been explained as to why this particular phrase occurs in these sections under 83, which provides for power of provisional attachment, which is same as 67, monarchs, which is same as 70, which is same as 69. Entire scheme of the act. Lastly, I would like to submit for Lord's kind consideration. Lordship, what is the prejudice caused to them today? With great respect, my lords, they've issued a show cause notice. Lordships. Today or tomorrow, my lords, let us assume your lordships issue notice to them, invite a reply, my lords. And ultimately, your lordships hold that I have to go into adjudication, my lords. What is the prejudice caused to them? There is no demand today against me, my lords. And the act also provides that the period that is spent before your lordships have to be excluded. There is no time bound, etc., my lords. What is the prejudice being caused to them today, my lords? When I am questioning the jurisdiction of the officer invoking powers under 67 and 70, it's a pure question of law, my lords, which your lordships need to adjudicate, my lords. 2, natural justice, my lords, I make a detailed representation. They rejected on the ground that I've already issued show cause notice. None of the reasons, with greatest of respect, my learned friend just made submissions before your lordships, come out from the letter of the commissioner. He could have very well given these reasons to me, my lords. I would have known and I would have a different course. Certainly, my lords. Today, these reasons are not on record, my lords. I am handicapped to even give a reply to this, my lords, because this is not coming out of the record. Let my learned friend put it on oath, my lords, then I can get a chance to rejoin to it, my lords. That's my limited prayer before your lordships today, Lord. Lord, the judgment, my lords, of the Supreme Court, which is relied upon in the case of postal, my lords. Kindly have para 30, my lords. This is what my submission is, my lords. The Supreme Court is saying this, my lords, that there is no bar in entertaining a writ petition against the notice, my lords. Our lordships are aware of your plenary powers under 226, my lords. The Supreme Court only says that where you should invoke and where you should not invoke. Can you look at the facts, my lords? What was the case? Lordships, this was a matter where there was a dispute about classification of service, whether it is cargo handling service or whether it is a goods transport agency service. Look at the dispute. Obviously, the Supreme Court is saying whether it is A or B, let somebody adjudicate. I am not saying, I never said that this is not royalty. I never said that this is not works contract. No, that's not my case. My limited case before your lordships is purely based on jurisdiction of the officers to conduct this inquiry, to conduct this audit in the garb of inquiry and issue this notice to me. 1, that's the root of the matter, jurisdiction, which your lordships can entertain. 2, before coming to your lordships, I go to them saying that please give me reasons which you ought to give me. They rejected on the ground that I have issued show cause notice. That is no reason, my lords. Therefore, it is clear case of violation of principles and natural justice. Therefore, I am before your lordships. My lord, I give a 25-page application to them. I have no reason. I have no difficulty if they reject it with reason. There is no reason. That ground itself is enough, my lords, for your lordships to entertain this petition, saying that this one-liner letter from the commissioner is not good. There are no reasons, my lords. And therefore, my lords, even going by para 30 of this judgment of the Supreme Court in post, it supports me. Supreme Court says if there is a question of jurisdiction, High Court should entertain. If there is a question of natural justice, the High Court should entertain. I am invoking both, my lords, for my lords' kind consideration. Lordship, they can file their reply, my lords. That's my respectful submission. I'm grateful, my lords. I'm obliged.
It's just for one clarification. My landed friend is that they have submitted a application of 25 pages. It is not correct. It's only 11 pages. But so please to see what document they are asking for. Page 142.
I can read out the entire application, my lord. There are several points in there. If my learned friend wants that, I will do it. Let me read out the entire application, my lords. I have not asked one, but 10 different things.
You have submitted. Let me
Lordship.
complete my argument.
Lordship.
Page 142, Lordship. 1. From the foregoing, it appears that the reason to believe to invoke the exceptional jurisdiction under section 67(1)(a) of Central GST Act and Assam GST. So he's asking for reason to believe. I've already submitted judgment, Lordship, that we can place before a Lordship for perusal, not to him. 2. Copy of authorization that has been supplied to him. 3. Copies of documents may be furnished in support of assertions made in SCN, being a word contract is paying royalty to the Forest Department Assam, and confirmation may be provided whether this information was published by applicant. Then 4. Entire SCN from paragraph 9C to 9333C discusses the taxability of the royalty, but there is not a shared of evidence to show that the GST on royalty on reward charge.
Okay, this is something I'll go through it.
So Lordship, these are the documents they are asking for.
I'll examine it.
Lordship,
Lordship, may kindly have page 139 just to answer.
It's okay.
this.
I'll just
No,
examine
in
it.
my statement that they record, I've told them I've paid GST. Kindly have page 139, question 9, my lord. Just for 1 second, I'll rest my case.
I'll examine that.
Lordship, I paid GST to the state. There cannot be a double demand. That's what I'm telling them.
Heard Mr. B. Raichandani and counsel for the petitioner. Also heard Mr. S.C. Callan and standing counsel for the GST, who has raised a preliminary issue, preliminary objection as to maintainability. First one. Matter of maintainability is heard. List on students for delivery of orders. I'll fix a date after some time because I don't know my roster.
Lordship,
Date, you'll correct it after some time.
Lordship,
Next date.
Lordship.
It will be sometime in the 7th June 2023.
Lordship,
Because I'll be intermittently out of station.
Lordship. Much of
7/6 is a Wednesday. Any difficulty?
Which can it be a Thursday or a Friday, my lord? Because Monday, Tuesday, the tax bench takes it in Bombay. Wednesday is Delhi High Court, my lord. My apology.
Okay.
So either
Friday.
Thursday or a Friday, my lord. Or lordship,
Eight.
my presence is required for that day or
No, not
lordship?
required because it will be delivering orders.
Then your lordships can fix as per your lordship's convenience, my lord. Lordship may keep it as per your lordship's convenience.
Okay.
My apology, my learned friend just said that there is not requirement. I will not be.
No, it's not required.
Lordship.
I'll be just delivering orders. I've heard it. The judgments to be perused.
Lordship,
Recommending I'll be traveling next week, so.
Lordship. Great.
I'm
We are
respondent
obliged.
number 1 on behalf of K. Paul.
On the other cave, nothing. I didn't do it.
19.
Yes.
Met the loss. That my lord. The judicial my lord, my lord. Take
Ah,
your-
yes, yes.
Yeah. Your lordship, in one of the case, my lord, your lordship, some must order, my lord. Yes. Huh? This case also, my lord. I think your lordship order is there, my lord. In this case also, my lord.
Yes, yes.
Page 57 is a matter similar matter that final termination and already other cases are pending. The status was granted by the page 57. And the lordship was pleased to observe that the next date that will be considered in the light of that order, man.
Yes.
Yes. Page 43.
Yes.
Page 42, madam. We are coming, madam, because how your lordship raised the question about the agreement, my lord. I am aware of that, my lord. But page 42, earlier, these petitioners, madam, now they have come individually. Earlier, all of them joined together and they filed one writ petition. This is page 42, madam. Here, the present petitioner was also there, madam. One of the petitioners. In that case also, we came apprehending that they will, my lord, terminate. Then in those kind of page 42, madam. That was on 26/4/23.
Yes.
There is no such decision to terminate the franchise of the petitioner. He has further drawn the attention of this court to the communication data so and so, which though relates to termination of certain franchisee, the same is not connected with the petitioners. So in next year, now you'll pay 43, you will find in plain order. After 1 week, 5 days now. All over Assam, my lord, all remains intact, nothing, my lord, only this petitioner because of some reasons, my lord. Page 43 is the MP order. Clear, ma'am. Right, my lord. You take it, madam.
Yes.
So what they have stated, my lord, it is no longer commercially expedient for APDCL to continue with the contractual obligations. And therefore, in terms of clause 14(2), termination clause. Your lordship kindly have a look to my lord, that act, my lord, section 5, section 3, etc., my lord. And agreement, my lord, I take your lordship to agreement. Agreement, my lord, page 20, it starts. For 14 and 18, I take your losses for 14 and 18. They have my lord, the notice was given under section 14, Roman 2. Page 31. The APDCL reserves right to terminate.
Yes.
Yes. The APDCL reserves the right to terminate the agreement in the event of non-compliance of the terms and conditions of the agreement to be executed with the franchisee under the scheme after giving 7 days notice to the franchisee. This is number 1. Number 2, the agreement can be terminated by the either party by giving a notice of 1 month in advance. This is how this they have invoked. Third one is the PDCL reserves the right to terminate the agreement in the event of exceeding 80
and loss of the franchise area beyond the present limit. Then 18 your loss kindly see 1/8. One eight minus surplus minus small b minus. This money and 1A agreement has been executed and delivered in India and its interest so and so. Number 2, any dispute arising out of compliance, non-compliance of this agreement shall exclusively under the jurisdiction of the High Court at Guwahati. So now the question will come, my lord, in P order what they have taken, that it is, they have given some reason, my lord. That for page 43, again, I take your lordships to, that it is no longer commercially expedient for a PDC also. So it is not simple as it is simple 1 month notice, my lord, it is not there. And your lordship, I take your lordship to your lordship the other day, your lordship has stated how you justify since agreement is there. So the alternative remedy is there, my lord. But your lordship very much aware, my lord, latest decision, my lord, libel, just latest one, my lord, I am giving to your lordship. 2023 libel Supreme Court page 770. No, Ahmed Godrej.
2023.
Yes, 2023 libel within bracket SC 70. 70.
Can you give me the name?
Yes, name is my lord MS Godrej Sari Lee Limited versus Excise and Taxation Officers. Yes.
For other matters, I think this all other matters will be adjourned. This will take no to the council sitting. I think this will take some time. Other matters will be adjourned.
Honorable Justice Madam Jan Sharma used to say, your lordship, once case start, others can go.
No, because I would not like others to wait.
If your lordship, I may have the.
No, just. Not sensitive. Okay. 21. 6 SCC 771.
21 6
21 6 SCC 771.
21 6 21 6
No, that is different. SCC which I referred.
Oh, no, I am your lordship. No, I am also referring one SCC to the.
Oh, achha, okay.
Now, this libel I have given.
Oh, okay. Yes, one you are setting is libel, other is
Yes, other is 2021 6 SCC I am giving your lordship.
2021 6
6 SCC page 771. Radhakrishnan Industries.
Oh, achha.
Para 27 and para 26 and 27. 27 in paragraph 27. Another case was my road that 2003. Urban Solal, that is important case. That is mentioned in paragraph 26 of this 2021 6 SCC.
Okay.
Then 2015 16 SCC. 120 page 125. Indian Oil Corporation Limited. Paragraph 32, 33, 34.
Yes.
Then 1993 SCC 752. 1990 SCC 752. Mohabir Auto.
1993 SCC.
1990
3 SCC.
752. Paragraph 12 and 30.
Yes.
Now, libel your lordship paragraph 4, madam. First one. paragraph 4, man. Before answering the questions, your lordship, paragraph 4,
Yes.
we feel the urge to say a few words on the exercise of the writ powers conferred by Article 26. Having come across certain orders passed by the High Courts holding writ petitions as not maintainable merely because the alternative remedy provided by the relevant statute has not been pursued by the parties desirous of invocation of the writ jurisdiction. The power is to issue a prerogative writ under 226 is plenary in nature. Any limitation on the exercise of such power must be traceable in the Constitution itself. Profitable reference in this regard may be made to Article 329 and ordinaments of other similarly worded articles in Constitution. Article 226 does not, in terms, impose any limitation or restraint on the exercise of power to issue writs. While it is true that exercise of writ powers, despite availability of a remedy under the very statute which has been invoked and has given rise to the action including in the writ petition, ought not to be made in a routine manner. Yet, the mere fact that the petitioner before the High Court in a given case has not pursued the alternative remedy, availability to him, it cannot mechanically be construed as a ground for its dismissal. It is axiomatic that the High Courts, bearing in mind the facts of each particular case, have a discretion whether to entertain a writ or not. One of the self-imposed restrictions, on the exercise of power under Article 26 that has evolved through the judicial precedent is that High Court should normally not entertain a writ petition where an effective and efficacious alternative remedy is available. Efficacious and alternative and effective manner. At the same time, it must be remembered that mere availability of an alternative remedy of appeal or revision which the party invoking the jurisdiction of the High Court under 226 has not pursued would not oust the jurisdiction of the High Court and render a petition not maintainable. In a long line of decisions, this court has made it clear that availability of an alternative remedy does not operate as an absolute bar to the maintainability of the writ petition, and that the rule which requires a party to pursue the alternative remedy provided by statute is a rule of policy, convenience, and discretion rather than a rule of law. Though elementarily, it needs to be restated that entertainability of maintenance, that is another aspect, my lord. That is entertainment and maintainability. Even if it is maintainable, it may not be entertained. So distinction between entertainability and maintainability is discussed by the later part of this paragraph. Why only question, my lord, it may have remedy, but it is not efficacious and effective remedy. Now we are trying to work to the 1/6 assessment. Radhakrishna Industries.
Yes.
Paragraph 26, my lord, it is just is referred to another that Whirlpool, my lord, and Harbhajan Lal. Simply, my lord, same thing, my lord, your lordship. So far, the view taken by the High Court that the remedy by UF goes to arbitration clause available to the appellants, and therefore the writ petition filed with the appeal was liable to be dismissed is concerned. Suffice is to observe that the rule of exclusion of jurisdiction by ability of remedy is a rule of discretion and not one of the compulsion. That almost same line, madam. Now take 27, your lordship, paragraph 27. 27(1) 2 and 4, Your Lordship. 27, 1, 2 and 4. Your Lordship got it, man. Paragraph 27.
Yes.
The power under so and so to issue it can be exercised not only for the enforcement of fundamental rights, but for any other purpose as well. Then 2 miles. So 27.2. The High Court has the discretion not to entertain a petition. One of the restrictions placed on the power of the High Court is where an effective alternative remedy is available to the aggrieved persons. Then 27.7.4, my lord. An alternative remedy by itself does not divest the High Court of its powers under 226 in the appropriate case, though ordinarily a writ petition should not be entertained when an efficacious alternative remedy is available. Almost same thing, my lord. So in short, my lord, and only one judgment I'm just showing, my lord, when the high ups and the lower up, weaker, because I am the person who is in need of something, my lord. And you have entered in the agreement, you are in the upper side and I am the lower side, man. Just 2015, 16 session, I have given my lord. Page 125.
Yes.
Page 125. Yes. 33 onwards, my lord. Section.
This principle is that force will not.
33, my lord. 32 is unconscionable, my lord. 33. This is the argument given by Mr. Kapil Sebal, my lord. That 32. That condition number 8 of the letter of allotment is unconscionable as it gives IOCL an unfettered right to terminate the discretionary distributorship without assigning any reason. In our case, same thing, man. Simply 1 month notice without any unfettered mind power. In the instant case, respondent is far weaker in economic strength and has no bargaining power with IOCL. Your lordship got it, man. So we are the unemployed person, my lord. You have come up with some program, with some scheme, and that scheme is fundamental as per section 5 of the Act, my lord. They have to do it, my lord, because it comes under exception section 14, my lord, it exception. So you have to do it through me, and I am doing that excellently well, my lord. I have generated, my lord, that income best of my way, and it is, my lord, it has given profit to them also, my lord. Profit to them also. 1 week back, you are saying that there is no decision to terminate. After 1 week, what heaven falls, my lord, that you have not decided that you are going to terminate it, my lord. When it is not the case that, my lord, that I am the non-performing that year. In earlier cases, my lord, 2 lists were there. One is performing, another is non-performing. My case, a specific submission, my learned friend has given on instruction that I do not fall within the non-performing category. That was submission given by them. Then, my lord, how they can say it is not viable, economically viable? It is not that simple. I am giving notice. They have given some reason. And if it is there, it comes section 14, subclause 3, my lord. Roman 3 comes. Loss. Your commercial, if they say it is commercially not viable, means some reason is there, the commercial law. You must show that commercial not viable. My specific case, I have given abandonment also, my lord. The profit, how much profit I have given to you. And it is essential. I am not that, because since suppose you get me out, who will do it, mother? Somebody else will have to be, my lord, entrusted with it. Because Act says that it will be given to the franchises, given to the Panchayat, given to the corporation, etc. My lord. So in that way, my humble submission is, my lord, because jurisdiction is there, and so far dispute resolved, my lord, agreements say about the dispute resolved. Your lordship, paragraph, your lordship, and this is page 30.
Where do you find that provision that it has to be outsourced? Where is that?
Section 5.
Yes, section 5. Electricity Act, this.
But we have extra copies.
Which act?
Electricity Act
Oh,
2003.
we will have it. We have it.
No, section 5, your lordship. Basically, it starts from section 3.
Section,
It starts from 3, madam, basically part 2, National Electricity Policy and Plan. This is the main, then your lordship may come to 5, madam. From that basis, madam. Section 5, National Policy on Electrification and Local Distribution in Rural Areas. The central government shall also, your lordship got it, madam. Section 5.
Page 12.
Page 11, if this is the book. Or different. Section 5, madam.
in that book, what is the page?
Page 12.
12. Ah, yes.
Yes. So starts from section 3, madam, policy. Now 5 say that the central government shall also formulate a national policy in consultation with the state governments and the state commission for rural electrification and for bulk purchase of power and management of the local distribution in rural areas through panchayat institutions, users associations, cooperative societies, non-government organizations or franchises. Then you'll also kindly come to my section 12. Yeah. Section 12, you'll also go to that. Authorized persons to transmit, supply, etc. electricity. That is direct APDCL can do it. No person shall transmit so and so unless he is authorized to do so by a license issued under section 14 or is exempt under section 30. We come under section 13. Power to exempt. Your lordship got it, section 13. The appropriate commission may, on the recommendations of the appropriate government, in accordance with the national policy formulated under section 5 and in the public interest, direct by notification that, subject to such conditions and restrictions, if any, and for such period or periods as may be specified in notification, the provisions of section 12 shall not apply. The direct manner shall not apply to any local authority, panchayat institution, users association, cooperative, non-government organization, or franchise. So ultimately, they'll have to do it, my lord, to this groups, my lord. And now, if you also can see the agreement, my lord, the recital in the agreement, my lord. What we are saying, my lord. Section 12 authorize them, they can do directly, my lord. Section 13 exception, section 14, my lord, it comes in terms of section 12. 13, but we fall under section 13. And they cannot do it, my lord. They cannot do it directly. That's why, my lord, we have been interested in that. Now, language of the agreement also, your lordship, page 21. Page 21. Just my lord, I'll conclude, my lord, I'll not take your lordship.
Section 3, 5, you are saying you are covered by 13.
I come under 13, exemption. Because 12, they can directly, my lord. It starts from 5. 5,
Yes.
12, 13, and 14. 12, my lord, connected with 14. And I come exception to 12, my lord. So mandatory, they'll have to do it, my lord. And agreement just by the page 21. Page 20, agreement clause. That we can and bigger, my lord, because prescribed format their place. Naturally, we have no other option, we put a signature, my lord. And that's one had gone into my console. It is a time, it is a place, my lord, when we have no other option but to put signature. Now, page 20, your lordship can see, it is almost prescribed format. Page 21, now your lordship can see. Page 21. First, whereas your lordship, whereas the first party agreed that the second party may undertake the management, first party agrees, ma'am, that is the PDCL. Second party may undertake the management of local electricity distribution network in the areas assigned to the franchisee. Revenue-related activities, including repair, maintenance activities as applicable as per this agreement, and other related activities as detailed under subsequent paragraphs in the specified area within the jurisdiction of the first party, subject to terms and conditions as stipulated from time to time by Assam Electricity Regulation Commission. This is, we are also having, my lord, that regulation we are also having. It is also details, it is there, my lord. Regulatory Commission in a specified area within the jurisdiction of the first party. So, my lord, ultimately you have decided that it is to be done by them. Now, once you terminate, who will do it, my lord? Next time you will have to give to somebody else. It cannot be done by them directly, my lord. And our abandonment is there, my lord. We have, my lord, tremendously, my lord, excellent performance with my lord. Paragraph 12 we have given, paragraph 12, my lord. No loss at all, my lord. Paragraph 12 of our my petition, my lord. And about dispute resolution, my lord, your lordship will find that is paragraph clause 15, my lord. Paragraph page 31.
That I've seen managed DGM or something like that.
That is there. So they have done it, madam. Then also they could have done it, madam. We have no other option, madam. We had to come here, lordship. There is no efficacy remedy. And only main question, my lord, 1 week back, you were saying that there is no decision terminated. And on the similar point, my lord, that 357, this honorable court already passed a status order, my lord. So my prayer is that, my lord, keeping in view of the situation which I have played your lordship, my lord, subject to your lordships, my lord, this at this stage, my lord, your lordship may examine some other matters are coming, about 8 matters, I think we have, my lord, 8 matters. Tomorrow, some matters are also there, my lord. So at least at this stage, if status quo also maintain, my lord, we can maintain ourselves, my lord. We have employed workers, my lord. We have invested some money in infrastructure, everything is there, my lord. And 1 week ago, you were saying, no termination. We have actually more, we have investment we have made, my lord, because of that also, my lord. So that basis, my lord, saying we stand on the weaker side, my lord, and their stronger side should not take advantage of our weakness, my lord. This is my humble submission.
Okay. Your part will hear tomorrow because I have a meeting right now. At 4:30 I have a meeting. You can finish by 5 minutes.
I'm sorry, man.
You can finish today by 5 minutes.
It takes some time, but
Report some instruction based on again.
Mr. H.R. Chaudhary, Senior Counsel, assisted by Mr. M.A. Chaudhary, then Counsel for the petitioner. So their submissions are concluded. Reserving right to reply. Mr. B. Chaudhary, learned counsel for the correspondence is present. Tomorrow?
But tomorrow item 7 we are having a motion, no?
Yes.
No?
Tomorrow 4 matters have come on.
Can we ask matter? We'll take it up as the last matter in the day. We are listing it.
At 2 matter is possible so that we may be certain that motion 7, item number 7 is there, motion.
Okay.
One of the.
So in that also, if you can make submissions, we'll take that.
Yes. Same
Item
submission in all the
It will be
cases.
same submissions.
Yeah, tomorrow 1 motion, another 4 cases also come. Supplementary. He will give the list tomorrow.
Okay.
About 5 cases tomorrow.
Okay. List, give the date tomorrow. This was answered for submissions by soon. Because Even tomorrow I'll be rising early. In fact,
That's true, we understand, we are
Tomorrow-
sorry to. my
tomorrow
lord,
morning
detain your
I'll
lordship.
be rising more early.
Well, we have no other option, my lord, I am sorry.
No, no, it's
to
okay.
detain.
No, no, it's okay.
We are also in extreme, my lord, we are the day after
No, no,
tomorrow, we are-
no grievance against you, but
No, my lord, we understand. your lordship.
management of time
So
is,
many engagement assignments are also there, madam. That's,
tomorrow I have to give a lecture in the academy.
that's, madam, we understand. But this time Sobina is very nice, madam. That's Sobina, your lordship.
Okay, you got it because of your contribution.
Very, madam, it actually get up everything. I wanted to say to your lordship, room and to say that, my lord, that very good, madam, very impressive.
No, thank you.
Very,
Appreciation is appreciated.
very impressive, my sir.
I have to tell the team, they'll appreciate that. But we also you see the difficulty is that we need a real feedback. It was very difficult to understand whether it's an appreciation or it's just an okay.
No, not just okay, madam. It is really from top to, I have done almost one, get up everything, that's, that it shows the mind of the team, smile. Very nicely it was. Very nicely.
Thank you. Very good contribution came from Honorable Justice Mani Chaudhary.
Concern matter, very hurried, I have done something to.
Justice Mani Chaudhary,
Madam,
he did the
Yes.
more hard work.
but your lordship was also, so,
No, it's there, but
yes.
I did some work, but he
Anyway,
did the
keep
hard
work,
work.
madam. Credit goes to the
I
whole
did some work, but he did the hard work.
team.